May I please, Your Lordship? But item 41, my lord, will be taken up next week, my lord. In the meantime, my lord, postmortem report also may not come, my lord. Well, I'm saying that if possible, my lord, then next week, my lord.
41.
41, my lord.
Yes, 41. What is the position?
Yes.
If I have
41
casually received, my lord, PM report is not available. PM report not yet received.
In the meantime, he is seeking adjournment.
Yes.
We can retain the case day. You can call for the PM report if it is required. Or you have what to do.
Really, this update may be fixed.
You are not on interim, I think.
No, my lord. I think.
He intimate that one other case is also my lord checked with the right. We regularly check to it. One other case is also pending my lord, regarding the present.
That is regular bill, my lord. But BA 191.
PA?
191 of the 26.
Yes,
It is 20 this time.
20.
20.
Okay, then it can be retained.
yes, yes.
Can request with Mr. and obtain the done consultation. Matter is adjourned. CD receipt. CDB retained till next step. In the meantime, there are done it additional PP also communicate with the IO for procuring the PM report. List the matter along with BA 191 of the investments on 2002.
May it please, Your Lordship. Lordship, I'd like to mention item number 22 to 29, Lordship. Let this
These
matter
are all
come up.
connected matters.
Yes, Lordship. Let this matter come up first week of March, Lordship. Because, Lordship,
Otherwise, CD received, my lord. I have received the CD, my lord.
in all these cases, Lordship, we are on interim, Lordship. Some more person are coming, Lordship. They all the item can be taken up together, Lordship. That's why I'm praying for on first week of March or 23rd onwards, any day, Lordship.
22 to at request by Mr. Chobe deduct consultation. It is adjourned. However, it is submitted by Mr. Waterpool and additional PP that CD received. Considering the submission made by Mr. Chobe, the matter is that the matter be listed. You want to take first week of March? First week of March,
Yes, Lordship.
5th of March.
Interim may continue.
CD to return good. CDP return, directing the investigating officer to submit the updated list. Interim be continued till next.
Highly obliged.
May I please, Your Lordship? Your Lordship, I'd like to mention for listing of a criminal revision, Your Lord.
Make a mention before court number 8.
Your Lordship, yesterday new roster has come, Your Lordship. Your Lordship is the senior bench for next. Your Lord.
Please, Lordship, I kindly request you for mentioning, I kindly request you for listing of my anticipated death.
Court. You make a mention before court number 8. That is the senior batch.
Yesterday, but
Court number 8.
yeah, yesterday I mentioned them.
Then what happened?
They told me,
Yesterday you mentioned.
yes,
Then what happened?
they told me to go to the room number 8, or courtroom number 14, sorry.
No, in that case, we are not may not be in a position to fix your allow your mentioning matters. So you just intimate the registry in that.
Much better.
Please, Your Lordship. Lordship, I beg to mention item number 38, my lord. On this matter.
Case diary received, my lord. CD received.
Yes, what is your
My lord, for the next week, my lord.
are you on interim day?
Yes, my lord.
With positive outside it. 23rd of this
Right.
next.
The interim order maybe.
23rd interim because in privilege state of listing, CDB retail privilege.
Biblioplex. May I please your lordship? Lordship, I beg to mention RSA lordship.
What?
RSA lordship.
Make
For
a mention before
listing for hearing.
listing.
For hearing lordship.
For hearing. You make a mention before court number, huh? 13 no hoy. RSA Pune. Provincial Consulate. They have to mention कोईटा question है माने civil match 1 or 2 कोण लेते one civil match 1 court number make a mention before court number 25. We are not taking this civil match. That's I'll say you can make.
Very lordship. Lordship, hearing matter item 48. I am for the appellant.
Item 4048.
48.
Yes.
Lordship, I am for the appellant. My lord, in this case, respondent number 1 already denied. So I filed one application to implement of the necessary party along with the court of decision yesterday. So matter will be taken up with that. My lord,
Who died?
the respondent number 1.
Respondent numbers.
And there is an order passed by this court to
For
file a
implement.
necessary application. Yesterday we filed. That is
But Mr. Gabriel, the learned counsel for the appellant. It is submitted by Mr. Guyan that during dependence in this case, the respondent number 2,
respondent 1.
respondent number 1 died, and they are
Totally
going they
intervening application
they will
for
file an
implement
interlocutory application for implement of the legal years
along with condemnation.
along with a
List
prayer out. Yes, after 2 weeks will do, or you need a date. Date cannot be most probably after
Yes.
2 weeks. List after 2 weeks as the date. Will be. Okay, in the meantime, you file your application.
I look.
Yes.
May I please, Lordship? 483 application, Lordship. I was arrested on 4/1/26. Lordship. I'm behind the bar for 40 days. 305A. Lordship. The FIR says there some electronic items were seized from stolen away from the shop, and nine accused persons were arrested altogether. I was the person to provide the vehicle, that is I work as a broker, and then I provided the vehicle to some persons who intended this vehicle, and then only by my work in that is that I provided the vehicle as I work as a broker. And then since I was arrested 4/6/20 and 40 days behind the bars, nothing recovery from me, only that much.
Where is your forwarding? Where is your forwarding?
Forwarding,
You have annexed your forwarding?
Lordship.
No,
Forwarding,
you have not annexed your forwarding.
forwarding is there. There's no.
Page, my lord, your lordship may kindly come to page 16, my lord. 16 and 7.
16. As per the ground number 1, you are the prime accused and who played a key role in commission of the offense, and you also arranged the vehicles only for the transportation of these looted articles.
Yeah,
That is the main allegation against you. So you played a key role as per the grounds of arrest.
Lordship.
Then your lordship may kindly come to page 19, my lord, rejection order. Page 19, my lord. Serial number 6, my lord. third paragraph, my lord,
Hmm.
serial number sheets.
Hmm.
Case diary reflects accused Rajendra Naik. Rajendra is not a small-time thief. It appears that Rajendra Naik works with a group of thieves and they commit theft in a well-planned organization.
40 days behind the bar, length of detention here, 305 only.
Recovery in connection with delivery, do you have any information? Here from here, we cannot show you. You have not annexed any seizure list also.
No serious.
Then we don't know whether in regards to the recovery. From your position, there may not be any recovery, but do you have any information in regards to recovery? Do you have any information?
No, nothing recovered from me.
No, from you, no recovery. From the others, whether there is any recovery.
Recover, so by intimation, they recovered from some other person. Sir.
He is behind the bar for 40 days when it can be.
Yes, otherwise, my lord, it seems that he is actively involved in offense from initial stage. My lord. He is the main person for after my lord, commission of the offense. He is the main person for my lord, transporting all these my lord, theft articles. Otherwise, he is
Okay, in
also
that case, if you want to call for the case diary also, he is behind the bar for 40 days, so try to accommodate that.
yes, ma'am. Next week, my lord, 17 or 18.
17 to we cannot.
Oh yes, on 23rd.
22.
Please, your lordship. No, this is the petitioner was arrested on my lord 1/2 my lord. This year my lord. This my lord. Lordship may can you turn to the FIR my lord. That is at page 9. All the offences are my lord, 7 years my lord. Not more than that my lord. Here my lord, the petitioner was an employee of the informant my lord since long my lord. He was my lord, doing his duties with all efficient and all truthfulness my lord since long. So my lord, it's a soybean packing factory my lord. So my lord, there were some my lord, in the affair it reveals that my lord, there were some my lord, misappropriation regarding packing and some goods were transported my lord. My lord, this is the allegation against the petitioner my lord. They trusted him, but it is seen that he has manipulated or misappropriated some soybean my lord. Now my lord, my contention is that my lord, all the offences is below 7 years, my lord. It makes it. And the forwarding report itself, it is written, my lord, that 35 my lord, compliance is not there, my lord, because, but Lordship knows, my lord, there is a recent judgment of the Honorable Apex Court this year, my lord, January 15, 20, my lord, that, my lord, my lord, the notice is mandatory, my lord, in offences, my lord, which is, my lord, the note, from the forwarding report, my lord, the police itself, they have revealed that my lord, the notice could not be served upon him. That is at page 26. That if they serve notice, I may evade arrest.
Yes.
Lordship may kindly turn to page 26, my lord.
Ah.
Page 26, my lord, that's serial number 8, my lord. If notice under 35(3), my lord, what you got it, my lord. They have not, my lord, and my lord, it's a mandatory now, my lord, as per the Lordship knows, my lord, just notice.
Specific reasons is there, my lord, why 35 he was not.
But my lord, regarding the judgment, my lord, they has to, my lord, because I am a local resident, my lord, they cannot say that I will evade arrest, my lord.
Which para specially?
especially last if the last and last in the paragraph F, then E, even if the circumstances warranting an arrest in the last pages, my lord.
See, you see the line.
In my lord, the notice under
The line, last line. Even if suppose, yes, obviously, if it is there, even if the circumstances warranting an arrest of a person are available in the terms of conditions mentioned under section 35(1)(b), the arrest shall not be undertaken unless it is absolutely warranted.
my lord.
So if it's the specific reasons are there, in that case, may avoid the 35(3). But we are let us see the cause diary in the last para also same is there.
But paragraph D, my
Exception,
lord.
and the police officer is expected to be circumspect and slow in exercising safe power.
Oh.
That is the observation of the court. Yes, obviously 35(3).
That one notice, my lord, but
But
they
the
have.
question is that in some circumstances 35(3) cannot wait for 35(3).
But here, my lord,
There may
he is
be
the
some-
employee.
some
Yes,
ground
ma'am,
for
I can
which-
understand if a person, if a thief is caught red-handed, but here, my lord, lordship may see the circumstances. He is an employee of the here,
No,
my
see, he is an employee of the
But he will say-
employee since most probably many years he was doing. So
Yes.
after doing the services for many years, if such kind of things are done by him.
But he won't evade arrest, my lord. But the notice in such circumstances.
Okay, we are calling for the case diaries.
Lordship.
Call for. When it can be called for, we don't have any date. I think we don't have by 24. 24.
Lordship. Oblige, your lord.
May I please, Your Lordship, application under 483, my lord, BNS. The allegation under my lord 305A. 331(4) has been also added, my lord. He is behind the bar for last 69 days.
69 days.
69 days, my lord. My lord, the forwarding report, my lord, is
330?
at page 15, my lord. So what happened, my lord?
This is statutory is 305A is 90 days or what?
305
Tell us. 305 small a.
is, my lord, for punishment for 7 years maximum, my lord.
7 years.
7 years. 305. Theft. The government property, not private property. Which may extend to 7 years or shall be to be liable for fine to fine, my lord. My lord, 3 persons were arrested, my lord. The main accused Sanjay Das. Everything has been recovered
Your
from him.
petitioner is in custody since when?
Since, my lord, the 7/12/25.
11/12.
my lord. Today is 69 days, my lord.
Otherwise, it is 7 years, but 3314
Oh,
is 14 years.
Yes.
I mean, if
in case, my
if
lord, theft
they-
is committed.
in
my
case the lurking house trespass was with an intention to commit theft, in that case, it may be 14 years. That's why most probably he is in 69. Anyway, Is there any recovery and all?
My lord, everything has been recovered from this, my lord, accused number 1, Sanjay Das, my lord. Everything, my lord.
Have you annexed this scissor list also here?
My lord, Caesar list, my lord, we have not annexed, my lord, but the forwarding report itself speaks that, my lord. Not only the stolen goods, my lord, other things also have been recovered from this Sanjay Das, my lord, including a police uniform and some ammunition and something like that, my lord. And this Sanjay Das, my lord, I am a, my lord, Rapido driver in Gauhati, my lord. On the day of occurrence of the offense also, I was in Gauhati, my lord. Dispur police called me. I went to the police station along with my bike, my lord. Bike is still in the lying with the Dispur police station, my lord. Police called me. I went to the police station. They have
No,
then
you have annexed this scissor list also? No.
Caesar list is I have
where
not
do
annexed.
you
Lordship may kindly come to page, my lord, 19, that is the rejection, bail rejection order, my lord.
Yes.
And I will also point out from the forwarding report, my lord. Forwarding report reflects that some police uniforms also recovered
My lord.
along with some live ammunition, my lord.
Oh.
Page 19,
My
my
lord.
lordship, third paragraph, my lord.
I am also saying, my lord, that has been recovered from this Sanjay Das, my lord.
No, well, the present petitioner is my lord Pragyan Narjari, my lord. This is his bail rejection order, paragraph 3, my lord. Perusal of the city reveals that huge amount of jewelry, mobile phone, etc. were recovered from the accused along with other accused. It is also seen that live ammunition was also recovered.
My lord, lordship may kindly be produced the, my lord, the forwarding report, my lord. That is at page 15, my lord. The accused Sanjay Das is directly and unequivocally linked to with the deliberate nighttime housebreaking and theft committed on 5/12/25 at around 2 at Notun Para. The mode of entry through window, selective targeting, high value jewelry and the timing of the offense clearly demonstrate a well-planned criminal. His arrest is indispensable to prevent further concealment of facts and to ensure a thorough and uninterrupted inquiry. A substantial quantity of stolen property, far exceeding the articles mentioned by the complainant, has been recovered from his possession. Recovery of additional items not reported in the FIR is strongly established that the accused is engaged in repeated and organized theft and burglary activities. Furthermore, as stated in the FIR, one smartwatch is still untraced and one custodial interrogation of the accused can lead to its recovery and help identify the exact scene of disposal of stolen items. In my lord, the last part of this, my lord, page 16, my lord, in para 13 and 14, my lord. It has been revealed that co-accused Imamul Haq and Pragyan Narjari explicitly stated during their communication that he would wait for Sanjay Das for completion of the burglary, thereby confirming his readiness to assist post-crime escapes and handling of stolen. The deliberate coordination among all the accused persons, Imamul Haq and Pragyan Narjari, along with their decisions regarding financial gain from the burglary, clearly established a pre-planned conspiracy. My lord, I am involved in that way, my lord. But I am a Rapido driver in Gauhati. My lord, on the day of offense also, I was in Gauhati. Dispur police called me. I went to the police station. From here, my lord, I was arrested. My lord, further, my lord, I know this person as a police person on duty in, my lord, 6 Mile. And he used to hire my bike, my lord, for riding, my lord, to one place to another sometimes. In that way, I was connected to him, my lord. He knows my phone number. My phone number is with him. And his phone number is also with me because he used to hire my bike for traveling here and there, my lord. And because of that, my lord, I know him as a police person. And he, police uniform is also recovered from that Sanjay Das.
Your lordship may kindly peruse ground number 5. Otherwise, my lord, Caesar list, my lord, he has not annexed. So, my
He
lord,
is not annexed.
from the my lord, bail rejection order, it reflects that some live ammunition and also from the present petitioner, jewelry, my lord, and other my lord, items also recovered. But my lord, specifically, my lord, what are the items recovered from the present petitioner? Because my lord, because due to non-availability of that, my lord, Caesar list, my lord, it cannot be ascertained from this forwarding report also at this point of time, my lord.
Well,
And
already,
from
my
ground
lord,
number 5, my lord, recovery of police uniform from the accused is a highly alarming circumstance. Your lordship may kindly peruse ground number 5. my lord.
Yes.
So they are in fact, my lord, member of a larger, my lord, group. They in
my
fact-
lord, for that, my lord, I am behind the bar for last 69 days, my lord. Investigation is over, my lord. Whether my further custodial detention is necessary, my lord. If any investigation is to be done, my lord, by this time it is over, my lord. If anything further has to be recovered, that has also been recovered, I think, my lord.
Only the length of detention that can be, otherwise there are details.
During the, my lord, length of detention, my lord.
Why you have not annexed the seizure list here?
It was, that has not been, my lord, certified copy may not have been procured, my lord, because of that, my lord, I have not, from there, my lord, from Bongaigaon, my lord, that's why I.
Yes, send in the commission court
Shortly.
shortly. Problem is with short.
Yes,
Don't
my
have
lord, is
it.
a difficult thing. There is BA, my lord, that is also one.
You were on police custody also?
On police custody for 5 days, my lord,
Police custody for 5 days.
5 days.
69 days is considerable period, but that is, we don't have
Let's,
this list.
considering the, my lord, length of detention, lordship may consider my prayer, my lord. Because, my lord, now, my lord, nothing more to be recovered from me also from the, I think, my lord, investigation is
There
complete,
may
my
be
lord.
other persons also.
Well, maybe, my lord, maybe, but by this 70 days, my lord, they have completed, my lord, the thing part, my lord.
Next week, any date, my lord, as per the convenience of the date proceed.
Okay, 20. 20.
Yes.
None appears on call for the petition. List it accordingly after 1 week as on a date.
Lordship 483, Lordship. Lordship, there is another matter, Lordship, same FIR, Lordship, has been fixed for CD on 16, Lordship. Both matter come together.
In this case, my search kit submit
Charge it, sir.
from my lord, annexer 7, page 31. It reflects that, my lord.
Annexure.
Post.
Item 5, this one. Item.
It is 5.
Sorry, my lord.
On 16, Lordship,
What is the other number?
Lordship, BA 345, Lordship.
345.
Yes, Lordship. BA 345.
KTR,
16.
Call for the case diary list the matter on 16/2/2025 along with BA 345 of
All right.
Please, Your Lordship. Lordship, regular bail application, my lord. Petitioner was behind the bar since last 30 days, my lord. Offenses under section 305A and 331(3), my lord. My lord, only allegation is that a mobile phone was recovered from me, my lord.
mobile.
Mobile phone, my lord. The FIR is at page number 7, my lord. Respectfully beg to state that person says that taking advantage of no one at our home, some unknown thief committed theft by breaking the almirah and took away the golden jewelry, cash of rupees 3,50,000 approx along with one mobile phone without SIM card. And
So where we are saying your SIM card, I mean mobile is, you have annexed your.
forwarding report, my lord.
Achha.
It is at page number 12, my lord. No, I am a scrap dealer, my lord. I purchased the mobile from one Nozrul Ali, my lord.
here we cannot say anything. One, this is simply it is written because two persons were forwarded, and here it is written one stolen mobile phone belonging to so and so, one pair of golden color bounty identified by the informant. So from whom what is recovered, that is not here.
Not mentioned.
Simply mentioned that, but not clarified anything that from whom it is recovered.
And regarding the present accused, my lord, in fact, while he is trying to operate that mobile, my lord, on the basis of the technical analysis, my lord, he was arrested. Otherwise, my lord, he along with the entire group, he was involved, my lord, as per providing for commission of the offense.
I have purchased the mobile phone from one Nazrul Ali, my lord.
The miscreants were attempting to operate the stolen mobile of the infant. While trying to operate at that point of time, because of technical analysis, my lord, police apprehended him after technical analysis. And thereafter, my lord, otherwise, he stated that he was at that point of time on not only a mobile, because other articles are also there. He was along with other members, he was involved.
Other means there are two were arrested. One the present accused petitioner, other one Nazrul.
Yes.
Recovery from whom? And anyway, and then but are you on interim? Sorry, police remand
Yes, my lord. 3 days.
for 3 days.
3 days. And now 30 days behind the bar, my lord.
Maybe only mobile handset is seems to be recovered. Other gold ornaments, about the other gold ornaments, there is
Yeah.
URMS,
PM Ahmed.
part MS PM Ahmed.
Acting upon the raid was conducted at the rented house of accused Muhammad Raz Ali. Present accused is the Raz Ali. From him, other all these items, one pair of golden, these articles.
Oh, it is from Rajali.
Raz Ali. He is the Raz Ali.
But because, my lord, when I tried to on the mobile phone, then they trace us, my lord.
But thereafter, my lord, on being leaded by him, those articles were recovered from his rented house.
Especially one gold, I don't know, golden color or gold or what, I don't know. But
Yes.
anyway, was also recovered.
Yes.
What do you think? 30 days in custody.
30 days.
My lord, continuously, my lord, this type of offense is going on in that particular area. My lord. Difficulty is that they will again, my lord, commit same type.
They will again come. Undoubtedly. And let him be for some more days. And can be for 23rd, 24th. 20, 24.
Let's
Yeah, please also 483 application regular bill lordship. Accident 28/1/26. He are also receiving stolen property lordship. Then petition number 1, he is the owner, and 2 is his employee lordship. At this stage also will call for a diary on he was arrested on 28/1. Some gold ornaments are recovered. Because he is a jewelry shop. He is having a jewelry shop.
What?
He is not naming the affair. The thieves who were arrested, they came and showed the police that we have sold those jewelries to him. That is the allegation, as per the forwarding report. So at this stage, also will call for diary.
Why this jewelry shop owner used to buy or purchase?
Because they are also bona fide purchaser. They don't know whether it was a stolen one
You
or
can
a
say
genuine one.
It is questionable whether they are
That is questionable. That is questionable.
Anyway, it has to come from which place?
Lots of Haju.
Aju.
Please take up.
Yes, when it can be 20, 3rd, 4th, 23rd.
23rd.
Okay.
My lord, item number 8 also arising from the same FIR which my learned friend just relied.
Okay,
Is also another jewelry.
23.
My lord. Obliged.
May is a lordship. Yeah, my lord. Lordship may call for a report from the Howley police station, my lord. Whether any case has been registered against me or not. My case is a paragraph, my lord. What is it? Paragraph 2, no. 3, my lord.
Paragraph 3.
Paragraph 3, my lord. My lord. One person, my lord, Bilal Hussain, he has taken some, my lord, signatures from my check, my lord. Now he is threatening he will lodge the case against me, and police, my lord, paragraph 4, my police has visited my residence also after that incident. Will lordship read my lord, paragraph 3 and 4?
He, as per you, he took signature in a blank check.
Blank check, my lord.
By what? Why you have
My lord, one Bilal has taken, my lord.
He says Bilal has taken.
No.
Why you have put this signature?
I have written
Any
forcefully,
person
my
will
lord.
come and ask if you
Well,
ask.
forcefully, I have written, my lord.
But why? One person will never come to me and they just.
But admittedly, there was a business relation, my lord. That I admit there was some business relation, my lord.
Yes, but
Yes, I will get the report. Because till now,
so even if suppose even blank check you have put some signature on the blank check, suppose in that case there may be a case for
And
NI.
but my police is visiting my house. I stated, my lord.
still in this way, they are creating ground for the NI. Maybe later they can.
So maybe a ground for NI.
And my incident is of 24/8, my lord. Not now. And police is visiting now, my lord. That's why I'm
And
apprehending.
giving evidence, they will place statement.
Lordship may kindly
This can be
see.
used as evidence.
24/8.
8.
24/8. I've stated, my lord. 24/8, the incident took
If it
place.
is 24/8, then the filing of NI will be also difficult. Even
But they might have put the signature now, my lord. Signature was not put. It was a blank.
no, you have already put a signature on the blank check.
Blank check, my lord. Blank check, my lord. Blank check. No, date is not there.
Achha, as per you, they took signature on 24/8.
24/8. Now police is visiting, my lord.
Dismissal as a located and consultation. And also should be what is an application of section 482 BNSS bring for granting free respect representation, apprehending arrest in connection with any case to be registered under Howley Police Station, Barpeta. Is submitted by Mr. Abdullah that the police is visiting to his house in search of the present petition, and hence there is an apprehension of filing any case by one Bilal who took signatures on mm, signatures on a blank check of SBI from the SBI account of the present petitioner, showing by filling up 2 lakhs rupees, no, blank check, and also threaten not to disclose about the said check. You want any interim here?
My lord, till then, no correction.
The office data report we call for from Howley Police Station, District Barpeta, as to whether any case has been registered against the present petitioner in the said police station, and in the until the receipt of the report from the IO. It is further as an interim, it is directed that no coercive action shall be taken against. Let the matter be accordingly listed. Yes, when it can be listed.
My lord, 3rd of March.
Third of-
3rd, 5th of March. 3rd,
Fifth.
my lord, holiday, 5th of March.
Fifth.
Oblige, your lordship.
Fine.
I'm deeply obliged.
That is what. In this case, my lord, the informant, my lord, she took a loan from the Cholamandalam Finance Committee. In fact, I'm the senior manager of the finance company. So what did she, my lord, she defaulted in making payment. And in fact, my lord, she sold the vehicle to a third party without the knowledge of the company. And if your lordship, before I take you to that, my lordship will kindly come to page 60.
60.
60, my lord. It's an agreement by the informant with one Abu Hanif Ahmed. The loan was, my lord, was for till, my lord, for it was valid till 15/9/2029.
It's an agreement for sale.
Yes, this is a sale deed, my lord, the vehicle sale agreement, whereby, my lord, you shall see Rahima Bibi is the informant in the case, present case, my lord. And this vehicle was sold to one Abu Hanif Ahmed. Vehicle number is mentioned, my lord, and if your lordship comes to paragraph, my lord, clause 1, the value of the sale proceed is 5,86,790, my lord. And, my lord, 82,000 was paid, and the remaining amount, paragraph 3, my lord, 7,866 EMIs at the rate of 7,866, my lord, EMI was to be paid to the finance company.
EMI was fixed at
Fixed, my lord, this is in terms of the agreement, my lord. The total amount was sale price was 5,86,790. 80,000 was paid as advance, and, my lord, the remaining installments, my lord, it was to be paid at rupees 7,866, paragraph 3 of the page 62 of the agreement. So, my lord, this is not otherwise not permissible, because, my lord, unless and until the loan dues are cleared, my lord, one cannot sell. Now, this person, my lord, he defaulted in making payment. So, my lord, ultimately, the company, my lord, they initiated coming to know of this agreement, my lord. Initially, demand notices were issued, which your lordship will find. And if your lordship, before I take you to the FIR, page 28, my lord, annexure 3 is the loan application, my lord. Annexure 4, page 32. If your lordship, this is a statement of accounts, my lord. Lordship will see the.
So you were a financial company.
I'm the senior manager of a financial company. Now, what happened, my lord? Because of this default, sir, and because of the sale, my lord, which is in term, it was not in terms of the agreement, we initiated a case in Kolkata. And someone said that I had mentioned in paragraph, my lord, 8, sorry, my lord, paragraph starts at page 7, my lord, sorry, page 8. It starts at paragraph 8, my lord, and the appointed part is page 8, my lord. Middle part, my lord, if your lordship says, according to due to such default, the petitioner company initiated one case against informant by case number CS so-and-so at Kolkata on 3/12/2024. But the loanee informant, instead of payment of the loan amount and receiving the summons from the court, has filed the FIR on some million. Now, lordship, on receipt of the summons from the court, my lord, now this FIR is filed. Here, in the my lord, agreement, we are nowhere a party, my lord. It was not within our knowledge in the sense of the company, my lord. Now, lordship will see at page 23 is the FIR, my lord. It says that, my lord, one Khurshid Alam, who was working as a working in a showroom, my lord, at Suryakanta, sold the vehicle. He's basically a broker to one so and so, and the vehicle was financed to Solar Finance Company. That is the only thing, my lord. Now, probably a case of mistaken identity, my lord. Here, one Khurshid Alam, and the petition before lordship is Khurshid Alam Hussain. Basic allegation is against the second party in the agreement.
No, Khurshid Alam was working in a showroom.
He was a showroom, my lord. Probably he was the broker, my lord. He in fact, my lord, the vehicle was sold to one Abu Hanif Ahmed, my lord. And probably he was the broker, my lord. We have nothing to do, my lord. I'm working for the company, my lord. I'm a finance company. Due to default on payment of installments, my lord, we issued notices. And in fact, if your lordship, even a lordship can see at page 56 is one.
Why is this part of the, what is this?
It says, my lord, that the
EMI.
vehicle was financed by solar finance. It ought to have been solar finance, my lord. So it is the trusted copy. So for an amount of rupees 90,000, it was stated that the accused me in the meantime, that is the purchaser of the vehicle, against the said vehicle shall be paid regularly and paying the owners of the vehicle at so and so had taken the said car from the showroom. Thereafter, after 8 to 9 months, when the accused number did not pay the EMIs for that period, and when I searched, they came to know that the accused number 1 has already sold my vehicle, sold many vehicles in other states. Basically, allegation is against that person below, to whom the vehicle was sold, and he is the accused number 1. And Khurshid Alam was probably, he was the broker, and there's such, his name was as accused number 2. No allegation against Mijanur Rahman, the third accused. But, cases registered under 316 and 318, Milord. Now, how the
But
company
the sale agreement was between Abu Hanif and Rahima.
Yes, ma'am. And Rahima is the informant here. Since he failed to pay the installments, the agreement was that certain amount would be paid, an advance was paid, the remaining amount of EMIs was to be deposited by the purchaser to the company. He defaulted. We issued notices. Ultimately, when he came to know of the agreement, we filed a case in Kolkata under 406 420 at that point of time. On receipt of the summons, this FIR is filed against the purchaser. Here, here one name has been mentioned as Khurshid Alam. He was the broker. I have nothing to do. I am the senior manager of the company, working at Dhubri. This under the Dhubri jurisdiction. Now I am Khurshid Alam Hussain. And if your lordship can see the iCard, at page 19. She sold, violating the terms of the agreement, we initiated a case. How are we involved, How this is basically cheating and breach of trust. She committed breach of trust or cheating, without informing the company she sells sales of the car, which is impermissible. In fact, thereafter my statement was also recorded, on 15/12. Whatever documents were supposed to be given, we gave.
Statement recorded on
Yes, on 15/12, 15/12/2025. So we will cooperate with the investigation. We have nothing to do, because he doesn't have any personal knowledge or in his personal capacity. It is the company. The company initiates a case. I cannot be held responsible otherwise. I will cooperate with the investigation. Only thing, lordship will protect me. Whatever documents are required to be given, I will produce it before the IO. At least the facts have to be made clear. Otherwise, because of probably some mistaken identity, I am a victim.
Now regarding who is Khurshid Alam and who is Khurshid Alam Hussain, because bail rejection order of the trial court is there. This is where this petitioner Khurshid Alam Hussain approached before the trial court, and trial court has rejected the bail petition of the present petitioner. In the trial court order, there is no dispute regarding the identity of the present petitioner. He is Khurshid Alam Chaudhary, the present petitioner. And regarding the agreement between the informant and one Abu Hanif Ahmed, yes, there is an agreement between informant and one Abu Hanif Ahmed. He sold the vehicle to Abu Hanif Ahmed. And how this accused person, why he has approached for obtaining interim protection,
See, suppose identity, question of identity may not be there also. But even in spite of that, this person with the name that on Iman one Khurshid Alam, who is working at the showroom having its business, sold my vehicle auto car swings the accused number 1.
But after wherein discussion was made in solar finance office, office of the present petitioner, that Khurshid Alam was also there at the time of in the office of that finance company. So it reflects that regarding identity dispute, at this point of time it is difficult to ascertain, because along with Khurshid Alam also discussion was made in the office of the solar finance company.
That is her statement.
The question is that one, okay, solar finance company was there and he may be available at the present of time of this making this agreement and all this. But even if suppose the question is that this solar finance is not is a financial company, the finance company who's financing the loan and all these things. Right? So in that case also, suppose this any agreement is made between these two, the one this Abu Hanif and the Said Rohima, that case also
They are also,
I don't
my
know
lord,
his
it seems that
involvement.
both are, my lord, together, my lord, they are
Most
in
probably.
fact trying to avoid this, my lord, maybe, my lord, to the EMI of the company, and for that reason, probably they made in between them that agreement. That can also be a fact, my lord, because this type of offenses, my lord, it happens, my lord. The, my lord, who is already vehicle is hypothetical to the particular finance company. Thereafter, my lord, that person made agreement with a third party, and thereafter, when third party, my lord, he is in fact, my lord, knows very well, he is aware of the fact that I sold this vehicle, but otherwise it is not permitted. Thereafter, my lord, he again lodged against the third party an affair only to avoid EMI from the finance company. But this type of incidents, my lord, earlier also there was. Let him appear, my lord.
Even in the agreement, my lord, I'm not a witness, my lord. This is some other person.
Report to the PPF started at discharging his duty as a senior manager in Shoda Finance Company, and he is not be connected in the LS. However, one name is mentioned in the FIR as one Khurshid who was working as in a showroom. The present petitioner was only discharging his duty as a senior manager in the same. More so, one the one sale agreement was executed between the informant and one Abu Hanif, the accused number one, and as party said one said agreement, some amount the the uh, the sale agreement, as per the sale agreement, the vehicle was sold at rupees 5,86,719, out of which 82,000 was paid as per the agreement, and remaining 5,04,790 was to be paid in a installment basis with an EMI of rupees 7,866. The said agreement was also made between the parties, wherein there was no involvement of the petitioner or insurance company. However, when they failed to failed to pay the EMI, one case was initiated against the informant at Kolkata, high case number CS/280329 280329 of the 2024 on 3/12/2024. But after receiving notice of summons in the said case, the FIR is lodged against FIR is lodged. However, the present petitioner is moving in the said alleged offense, and he is ready and willing to extend his cooperation in the further investigation of his case if he is granted with some interim protection. Next, Mr. Bottom, United Petition PP submitted in this that there cannot be any question of identity, because as from the order passed by the learned court below, dated 11/12/2025, it is held that the present accused petitioner was the person against whom the FIR is lodged, and his bail petition was also rejected by the learned trial. Your interim protection was there.
Initial interim, thereafter, my lord, I appeared.
Huh?
Yes, my lord.
Thereafter, trial the rejection.
Oh, thereafter trial.
Yes, yes.
Acha.
Interim order is lordship at page 64.
Rejected, but after no, rejected now in the said case said anticipatory bail application, the present petitioner was provided with some interim protection, but After perusal of the case diary.
Yes, yes,
After perusal of the-
after perusal.
perusal of the case diary,
That page 67.
the same was rejected by the learned trial court and Miller. And thus is seen that there are sufficient, there does accordingly Mr. Court submitted that there may be sufficient materials against the present petitioner, and hence without perusal of the case diary, order of interim may not be passed. In that case, too, you have
No, but Lordship will just see
rejected.
page 67, Miller, for once.
Yes.
That Miller, Miller, I'll just the petition. I'll just, it was a very simple petition, Miller, without disclosing the facts. That is there. The Lordship will see the peruse the case last part, Miller. Perusal of case there shows adverse incumbent matters against the accused petitioner. In considering so and so, is not entitled to the previous. If anything comes out, Miller, Lordship will reject thereafter, Miller. Let me at least produce the documents.
So, but when you are granted with the interim earlier, what you have done?
Miller, my record statement was recorded, Miller, on 15/12. That is what, Miller. Pursuant to the interim order, my statement has already been recorded. But the documents, Miller, because these documents are not available with us readily at that point of time. The police, Miller, Lordship knows what happened. I have nothing to do otherwise. How can, Miller, otherwise, if let us, for the sake of argument, breach of trust or cheating, Miller? How can I cheat, Miller? Because I don't gain anything. Where is
But
the,
you
Miller?
were very much were present at the
No,
time of
Miller, merely being
of the-
present, Miller. If I don't derive any, Miller, benefit, how can, Miller, breach of trust or cheating, Miller, come into play? Say, Miller, I was in the discussion. Even in the agreement, Miller, there are two other witnesses. I'm not a witness to that. If going by the statement, well, and she has made a wrong statement. She has not disclosed that she has sold the vehicle to some other person, Miller. No, in the FIR. So, Miller, she defaults. She makes a false promise, Miller. She violates the agreement. And whatever statement cannot be taken as a gospel truth, Miller. Merely stating that it was in my presence. Can it be, Miller, otherwise?
past. Also, he submitted that after the earlier the petitioner was on interim previous bail. Subsequently, after perusal of the case diary, the learned trial court below had rejected his prayer for previous bail by its order dated 5/01/2026. Next point. Mr. Day submitted in this regard that though he appeared before the IO
On
and
15/12.
before the IO on 5/5
15 Miller.
on 15/12/2025, and his statement was recorded, but as he could not produce the copy of the other documents including the sale agreement, etc., before the court, as at that point of time it was not it was not in his position. But if he is allowed with some interim protection, he may produce all the documents, including the case which was filed against him, against the informant, and other documents. Considering the entire facts and circumstances of this case. And so circumstances of this, I find it justified. Okay, you will be under interim protection, appear before the IO within 7 days
Lordship.
with all the documents and all,
Lordship.
and cooperate in the investigation.
I'm deeply obliged.
931. 934.
Yes.
May I please, my lord?
Yes.
My lord, this is for transit bail, my lord. Similar petition I have moved. There are total 4 cases, my lord. One is already disposed of by Lordship, my lord.
Today, my lord, 3 cases he has filed. Your lordship, my lord, I would like to point out some from the, my lord, here, my lord, in the earlier order. May I be wrong, my lord? I would just like to point out to your lordship, because, my lord, otherwise your lordship may kindly fix it at 2. My lord, because, my lord, your lordship in the earlier order, your lordship may kindly, my lord, I would like to point out that the petitioner shall appear before the investigating officer, Cybercrime Police Station, Gurgaon, within 3 weeks. That the petitioner shall, your lordship, otherwise, your lordship has granted the interim protection to the petitioner for a period of 3 weeks, and also direction was made to appear before that concerned, investigating officer or IO of the police. But my prayer before lordship, if I may not be, but I may also be wrong with that, because the person concerned accused person is from the jurisdiction of that particular state. So in the case of transit anticipatory bail, only
He is not from Assam.
not
He's
from Assam.
No, he's from Assam.
He is from Assam, but case is
Oh,
registered.
yes, yes, case is registered.
Your lordship can definitely, as per preamble, your lordship can grant transit anticipatory bail for a particular period, only for the purpose of obtaining anticipatory bail from the territorial, from that High Court of the territorial jurisdiction or any other court,
That
Sir,
was missing, Nikki.
whether your lordship, can
No, my lord, already lordship has stated, my lord, that
for a particular fixed period, within that period, he can approach before the that court of that territorial jurisdiction, and he can apply for anticipatory bail. Then only, that court of that territorial jurisdiction can,
yes, that-
grant him interim protection for grant any kind of protection, for appearing before the arresting authority.
Yes, that part most probably is missing
Yes,
because
sir.
otherwise we are not in a position to directly grant him any
Yes.
interim.
Yes, so I would like to point out that only
Now
that aspect,
you want to submit that he,
only
apart from the direction to appear before the investigating officer, he may
yes, he
approach
may
the-
approach before the
approach-
appropriate court of the territorial jurisdiction, and
Yes.
that court will pass
consider.
appropriate order for granting interim protection, allowing or rejecting,
Okay,
But
yes.
your lordship can, grant
Only
only for a
transit.
specific period, so that he can approach before for that court for obtaining, transit and justification. So otherwise, by taking advantage of this,
Yes,
order, he can appear, and otherwise, ultimate, absolute interim protection he was already granted by taking. He will take advantage of that order,
Yes, yes. So will you rightly pointed.
I agree with him. Lordship may direct only that much.
Here one line was there otherwise.
Yes.
In page 380.
Yes.
Last para you see.
In view
In
of
view of the present petition is granted transit interim anticipatory bail for 3 weeks from the date of order
Yes,
with
ma'am.
the
It is
direction
for
to
3
appear
weeks
before
for
the
a specific
Cybercrime
period.
Police Station, Gurugram, as directed. The petitioner will transit interim bail shall be remain in force for 3 weeks, enabling the petitioner to approach the competent court.
Yes,
seeking
for approach
appropriate-
before the only for approach before the competent court, but not, he cannot, by way of this interim protection, he cannot appear before the arresting authority.
So you're saying that those conditions and all there should not be there.
Yes, madam. Otherwise, by taking the advantage of this, he appear before the arresting authority by saying that I am already under protection, and he will get protection, and that court also, otherwise would have no other option,
So in that case, you can do one thing. We can, from a state side, you can file one interlocutory application for modification.
yes,
Because it has
yes,
already been-
yes.
And rest we
And-
may give
we
some similar kind of thing. So in the
Only
last
for a
whereas
fixed
it
period,
was
only for to approach before the
competent court for appropriate relief
to approach it.
against to appear before the cybercrime court. So you want to say that in the last para it is sufficient.
Yes, that's very sufficient. Only for a specific period, your lordship can provide 15 days, 25 days, 30 days. Within that period, he can obtain necessary protection from the court of the territorial jurisdiction.
Yes, yes, okay. Yeah, that- Now, what is this case, present case? What is he? Who is he?
But same petitioner,
Same
madam.
petitioner in,
Same
Same
petitioner,
petitioner.
same
Same
petitioner.
petitioner.
There are four cases.
Cases.
Four cases, madam. All similar type of FIRs, madam.
Why they choose only you?
Well, in none of the cases, either the petitioner's name is mentioned or his account number is mentioned, madam. It
No,
is
in one case you have already stated in that case there was some transaction, but you are saying that that is the real Patan Bazar.
yes, Pardon Bajar, but that does not belong to the
That
petitioner,
does
madam.
not belong to you.
Yes, and
Now the in other transactions,
No,
in
no.
that case also.
nothing is there, my lord. My account, neither my account is mentioned nor my name is mentioned, my lord. Over telephone, they have informed. In the earlier, I have also submitted, my lord, that there are 4 cases against me, and they have provided me the case numbers. I have stated in my paragraph 3 of the petitions. All similar type of allegations, my lord, but no, neither the bank account or the petitioner name is mentioned, or nor any money is transferred. My lord,
Okay,
FIR,
Mr. Potakur, I have this record. I have deleted those paras
Yes.
and competent court seeking so and so to appear so and so. This last line I have read, the petitioner will be at liberty to file appropriate application for period as well
Yes.
within 3 weeks from today.
Yes.
He can.
Yes.
That will be under force till 3 weeks.
Your lordship
Yes.
can also fix a specific date, my lord.
yes. Lordship may fix a date.
It can be fixed.
Yes, after 3 weeks, any date, Lordship may fix.
There are date for it, that is till from today 3 weeks কি হবে দেখো আজকে ভিতর দিলে হলো না not in 9-3
Ninth. Only PS case numbers are different. If police station is same, only case number is different.
otherwise all are from Gurugram.
All Gurugram Cyber Police Station, only the numbers are different, and in one case section is different.
We'll put this.
Yes.
Entry could you A2 open and the other one you just file a
Yes, ma'am. Yes.
interlocutory application for simple modification.
Yes.
12 and 13 are also same, madam. Same.
Prohibition to public service.
Published.
So very rightly pointed out because the order and then what format was there, accordingly
Yes.
it was passed. So it's a very rightly pointed out by you.
Wait, please, your lordship. Lordship, this is a pre-arrest bail application, lordship. We are informant and the petitioner both are from the same village, lordship. FIR, lordship, will find on page 13, lordship. Whatever in this case, lordship, the informant cattle, lordship, this petitioner have a paddy field, lordship. This is the harvesting time, lordship. His cattle enter in the field of this petitioner, lordship. Thereafter, they have handed over this cattle to the petitioner, lordship. Now, this time when these things repeat, lordship, so there was a meeting going on, lordship, village meeting, that is on page 13, lordship. This petitioner, lordship, informed him about this. Out of lordship, there is a scuffle between these two petitioner, lordship. I have stated in para 3 in my page 3, lordship will find the facts, what has happened on that day, lordship. Para 3 in the page 3, lordship. Now they are trying to lordship settle the matter because lordship now they have approached before the court below and court has rejected the anticipated bail of this petitioner reflected in page 17, lordship. Kindly peruse that order, lordship. They are from the same village, lordship. Only because of this cattle, lordship, this things is happened, lordship. After lordship provocations and all these lordship scuffling take place.
This order is from the other case or this for
This case, Lordship.
for this?
Yes, Lordship. Lakhimpur PS case number 406, Lordship. Same case. The first paragraph it is stated, Lordship. Page 17. Lordship.
Yes, but
My lord, other page 20, page 19, my lord, serial number 9. After perusal of the case diary, my lord, trial court has found sufficient material against the present petitioner.
But the observation that is reflected on page 11, Lordship, on page, sorry, Lordship, paragraph 11 on page 20, Lordship. Now this petitioner is Lordship trying to Lordship settle up the matter, Lordship, only because of they are from the same village. If this petitioner sent to jail, Lordship, there is a less possibility, Lordship, they are settlement, Lordship. They are trying to settle this matter, Lordship. This petitioner side is trying to settle that.
heard Mr. Beechall, the learned counsel for the petition. But Mr. Beechall to learned connection. Sometimes both the use petitioners are same from same village, and there was a quoted earlier also for damaging crop by cows, etc. And at the time of the meeting, there was some altercation as took place between the parties, and for which such incident happened. However, there is talk of compromise, and the present petition is also ready and willing and his cooperation for the if he is granted with some interpretation. Right. Mr. Bott, PP submitted in that from the rejection of the Learned trial, he reveals that there are sufficient limited evidence against the present petition and assisted for the case study. But hearing the submission made by the counsel, considering will be under interpretation.
Highly obliged. Highly obliged.
11.
Highly obliged. May it please your Lordship. Lordship, this is the case, Lordship, we will find on page 16, Lordship. Whatever, Lordship, police in page 16 is the FIR, Lordship, anticipated bail application. Lordship, police in civil dress, Lordship, picked up one Baharul, Lordship. In a private car, they come in a private car, Lordship. They,
Today, my lord, in this case,
I've taken the time, Lordship.
22-29 already he has taken time today, my lord.
But the co-accused Lordship on the same Lordship on motion, Lordship is granted protected, Lordship. What happened, Lordship, in this case, Lordship? This police did not, Lordship, disclose their identity, Lordship. Then these village people, this Baharul Islam, I am not for Baharul Islam, Lordship. Baharul Islam raised UN trial, Lordship. They said, Lordship, this unknown person has picked up him, Lordship. There was a cricket match which is going on, Lordship. People of that locality, Lordship, rush to that place, Lordship, and they are asking the police, Lordship. The police have not shown them, Lordship, identity card. Neither they came in a police vehicle, Lordship. Now, taking that chance, Lordship, Baharul escaped from the site, as per my instruction, Lordship.
There are materials against all the accused persons, my lord. They are, my lord, in fact, involved in, my lord, escaping one Baharul Islam, who is involved in many other, my lord, cases. And all these accused persons gathered in a group, and thereafter, my lord, while police is trying to, my lord, caught that Baharul Islam, they in fact helped to, my lord, attack the police personnel, and thereafter, my lord, helping that Baharul Islam to escape from the police custody.
Now, Lordship, whether police has come in uniform or not, Lordship. They are coming in a private vehicle. They have not disclosed their identity, Lordship. That's why, Lordship, these people are suspecting, Lordship, they are not the police personnel, Lordship.
For those things.
That's why, Lordship, on interim, Lordship, let all the case may come up on, Lordship, 5th of already fixed, Lordship. In the meantime, this petitioner can be protected because other petitioner, other accused person named in the FIR, they are already protected, Lordship, on motion, Lordship. Because police has asked them, this petitioner, to produce the Baharul, Lordship. Now petitioner on run, Lordship. Other case, Lordship, those who are granted protection, Lordship, they appeared before the Lordship investigation officer, Lordship.
And where is the Baharul now?
Baharul is Lordship, he is pleadable, Lordship. After those, so this petitioner, Lordship, they are not connected with this Baharul, Lordship. They are the village people, Lordship. They are not aware of these things, Lordship. If police, Lordship, show them their identity, Lordship, they are the police personnel, that things would not happen, Lordship. And what happened, Lordship? Why this petitioner, Lordship? Why the just head of the Bihu, Lordship? Why petitioner, Lordship? This police personnel, Lordship, try to pick up the Baharul. I'm not supporting the Baharul, Lordship.
This
But
matter
these
may
things
kindly
is
fix on 5.3 along with other matters because in spite of having CD, he has adjourned all these matters.
Okay,
So,
fine.
this matter may kindly take up on 5.3.
since Lordship, others petitioners are protected, Lordship, may I
We
pray?
go for list on fact.
Since other
Even listing
petitioners
it
are
fact.
protected, Lordship, kindly.
In spite of availability of the CD, you took it on. Okay, 5.3. Yes, item number 18 also we are here.
No. Not that.
Scan copy of their lordship.
We have received this scan copy.
Scan copy received lordship. The petitioner is already in interim lordship. And the next date is fixed for 27/3/2026 for appearance. Lord.
So I'm ready to appear there with the regularly appear before the trial court. So kindly interim order my
Earlier, he was granted interim on 26/9/2026.
no 14/10
14/10.
14th October.
And interim was extended to 13 to 14 today.
Interim continues.
Interim was extended till today, Lord, as in the case record was called for. But in the case record, Lordship, MR report is there. The MR report, Lordship, it is most probably private hospital, Lord. So only that much is given that previous form surgery. No opinion and all, Lord. In the
Why his interim was granted?
on 14.
Because my lord, let me because on 2 or 3 occasions after filing of this bail application, CD was not received. So Honorable Justice Das was pleased to grant interim protection subjected to produce the CD. But in the meantime, after despite passing, no CD was produced before the court, and subsequently on last occasion informed that charge sheet has been filed in this case. So TCR was called for.
Where is the appearance there, Lord?
And your interim was granted on which date?
14th October.
14th of October.
14/10. 14/10.
26.
Let me here. 14/10. 25.
After, that means after perusal of the, even after the filing of the charge sheet, you were granted bail.
No,
Interim was extended.
during police investigation, I had been granted interim protection.
The last order is there, Lordship.
Lordship, may kindly go through the 14/10 order. Interim extended. No, Lordship is trying to appraise the order dated 14th October. That
Is not, there is no mention about the filing of the charges. Now, he is saying that,
But then
no, in the order,
it is in the CC.
no, I
No, no,
think it is,
charge-
the
cha-
order,
cha-
there is no
no,
reflection.
no, honorable court was informed that with regard to charge sheet on last occasion. By charge sheet, it is reflected in the order. January 22.
Or TCR.
22nd January, it is ordered by this honorable court that it is submitted that the charge sheet has already been submitted, right, CS number 24325, dated 23/10/25. I was granted bail on 14/10/25. Next, if we go,
Therefore, what was the order? You again interim extended.
interim was continued till filing of CD.
Oh,
But in the meantime, on last occasion,
It has been
Submitted on-
submitted by CS number, so in all for the scan copy is here, is the matter again on 30 order passes are there, that continue till date. Till date.
okay, so TCR was called.
yes,
So now what is your submission?
TCI is there not. Date of appearance, date is fixed on 27/3 note.
so far as my
Wait.
instruction, yes, sir.
Date of appearance note.
No, my lord. So far as the today's settled law is that when investigation has already been completed and interim protection has been granted and there is no any obstacle on a part of the accused person and so far as the prosecution agency between these two sides. So there is no any
Just tell
justified
me-
reason for to keep for to
Just tell me, when you were on interim,
yes,
you were grant interim, isn't it?
yes,
Then during that period, charge sheet is also filed.
yes.
Now, prior to the filing of the charges and between these dates, is there any date of appearance passed by
No,
the learned
because my,
tribunal?
let me submit. Actually, though interim was granted on 14/10, the accused person was released on bail after 1 month of granting interim
Why?
because he could not arrange any suitable bail.
Now, when he got, he was released on bail.
After 1 month of granting the interim.
Say, as per you, after 1 month, in that case also, let
Charge
it be
sheet.
in the month of November or
November.
last part of the November.
Yes, yes.
Thereafter, was there any date fixed by the court?
That will be reflect on because he has not get any summon till date in connection with the case, whether it is after charge sheet for appearance. Because he is outside.
Only one order I have seen, but very.
Committed till date it is not committed to the court also. Committed to the learned session judge.
So even after, even before commitment, you can appear, no? Where is the bar? There cannot be any bar.
So far as Honorable High Court has granted bail in this bail application by way of interim measure also. So there is no other reason for to pass any other order by deviating from previous order. So my only prayer is to make it absolute, subjected to my appearance on being received summons of the case.
Okay, yes. What is that? Otherwise, it is 109 case.
109.
Already on bail.
Appear not.
Huh?
It's appear before a court bill.
The
This is
receipt
the
of summons.
date, 27/3.
So, and the earlier order might be,
In the date of
Absolutely.
appearance, Lordship, due pays for regular bail in lower court, Lordship.
no, that is not necessary. That is not necessary. It is a very IPC case.
Heard Mr. A. Paul, the learned consultant. Ms. A. Beatty, the learned assistant payment. It's an application in connection. Scan copy of the decision has been received. It is submitted by Mr. Paul and also from the recorded review stat. The present petitioners granted with interim bail on 14/10/2024 by this court, and it is also reflected in the order dated 22/01/2026 that during the pendency of this case, the case, comma, it was charge sheeted, and the charge sheet is accordingly charge sheeted. So considering this aspect of this court call for the scan copy of the DCR, which has been received. The record is in that the next date for appearance is fixed on 27/2026 after filing of the charge sheet. Case is not yet committed by the learned. Mr. Paul, the learned counsel for the petitioner, submitted that the petitioner is ready and willing to contest the case by appearing before the learned trial below on each and every date to be filled by. Next paragraph, MS Begum, the learned is submitted in this chapter that there are some materials in the case diagram, but it is a fact that case has already been charged sheeted, and the present petitioner was an interim by its order dated 14/10/2020. Next part, considering the submission made by learning counsel and also considering the interim granted earlier with present petition. Court find the comma the earlier interim bail order dated 14/10/2025 is hereby made at same terms and conditions, and the petitioner is further directed to appear before the learned trial court below on each and every day to be fixed by the, and to abide all terms and conditions of the yep. Observation sent. The interim is we are making it absolute. Yes.
Mr.
Sir, there are 4-5 cases in all the cases, except 1 or 2, he got bail. And absolute bail. Interim got extended and ultimately got extended. These are the cases.
Yeah, because it's system na लिखने ने अगर ये जो भी लिखने को यू का बिले खबर पड़े पूरे कौन सी लिखने को क्या क्यों कम पूरी लिखते यू का बिले खबर पड़े मालूम हो जाए. One notification was there earlier.
Yes, Mana.
The cases disposed of the same petition or out of same FIR
Yeah.
will be dealt by one court. Because there may be differences of views and all.
Yeah.
Isn't it? Because this accused petitioner having 4, 5, 6 numbers of
Yeah.
cases, I think. So this kind of their submission is rightly submitted, they are considered, but for the court also there may be some difficulty on our part. Suppose if in same for the out of same FIR for the same accused person, it's difficult in fact. Present against the present accused Dharmeshwar Roy, how many cases are still pending?
This is the only last. All are disposed. Out of 6 cases, 3 got permanent bail, 2 reject on the ground of that, and 1 is this case. All the constitutive custody. think it's section in this particular case, section is 316, 319, 319, 318. They're all mandatory period is 60 days.
Those cases on medical ground, my lord, interim protection was granted. And my lord, the direction was that, my lord, on a particular date, you will have to surrender before the trial court. But thereafter, my lord, the petitioner has filed all those extending application in some of the cases, those were extended. My lord, in this manner, ultimately, my lord, those cases, some of the cases ultimately disposed of. Otherwise, there are sufficient in all the total 14 numbers of 13, 14 numbers of cases my lord, against same modus operandi, my lord, in the same way, my lord, he is involved in committing theft, committing, my lord, all these offenses, my lord.
Here one order is there on 12/11/2025 by this court. Is to release on interim bail for medical treatment with the direction to surrender before the chief judicial magistrate on 7/11.
Yes.
However, the learned counsel for the accused appellant said they could not surrender before on 7 as he was suffering from chicken pox. And so and so. Undergo required treatment. So interim was extended. Then on 7, then also.
Last order also 2021, 26, interim extended. In the last one. 29/1, 26 order. Interim order passed earlier shall continue till the next date.
So in all the matters, in fact, including this also for his medical condition, most probably interim was granted.
Yes.
So what is your as per you? What is the stage now?
No, he is not well actually. We have filed additional affidavit also. He is not well.
What kind of disease he is suffering now? At
This
present?
this earlier was that hepatitis. Huh? In all the cases, if you also go through the order, not only on the medical ground he has been his bail will make absolute, but on the merit also, my lord. If you also go through order, there's sufficient
No,
indication.
asking what kind of disease he
Oh
is
yes,
suffering.
this is now suffering from gallbladder.
Gallbladder only.
Gallbladder and hernia.
Okay.
And
Hernia,
that becomes septic, my lord. He needs immediate surgery.
Where is he gone for surgery?
Not yet gone.
Why, if his condition is so acute,
Yes.
then why is not gone for any surgery and all till date? Because I know hernia is very critical because the inner parts of the stomach comes out.
Yes.
So it's a condition that it needs surgery. But why?
No, after surgery, the complication, post complication arises after surgery.
Oh,
That is the problem. Surgery is completed. No. Actually, I have not. This is surgery is completed. Only post complication surgery has arises.
now surgery is there. Now post complication surgery, and in this case, one chicken pox also there.
My lord.
In this case,
Huh.
as per your submission, he is suffering from chicken pox.
Yes, my lord.
So
That was previous council submission. my lord.
So he's suffering from 2, 3, 4 diseases together.
Yes.
Gallbladder, hernia, chicken pox, other disease. What to do?
So now question is that, my lord, the disease and this is different issues. As far as maid part is concerned, 60 is over and investigation is completed.
There are merits, what to say. He is a veteran criminal.
So because merit
One
is
lady is also involved. His wife, I think, na? His wife is also involved.
Yes, yes. Otherwise, my lord, medical board has to be constituted, my lord, to consult.
Yes.
My lord. Otherwise, my lord, without that, my lord, because
If his condition is so serious, so
Yes.
medical board has to be considered for overall checkup.
overall.
Yes. Then what is your submission apart from your disease, other submission?
No, my submission is just simple, my lord. That 60 mandatory period is over. And they have not filed.
60 days.
Huh?
Maybe 60 days.
60 days.
And we have been.
And he is already inside already in bar. Once he was, earlier he was arrested, he was in bar for, he's in jail, not only in this case, other cases. Total, in this case also he's in custody for 27 days in custody.
Otherwise, regarding that constructive custody, their mandatory period completed, and at the time of granting interim protection, those mandatory period, statutory period was not completed, and those grounds were not accepted by any of the court, and there is no decision of the Supreme Court till now specifying that contention of the petitioner. Otherwise, only on medical, ultimately some of the cases that's granted only on medical ground and considering the
No.
merits of the cases.
So the custody is different thing. The
Regard-
custodial period is
that
27 days.
On that ground,
He was
not in a single case, he has obtained.
He is arrested in this case, particular case. He was shown arrest on 26/9. Interim granted on 23/17/10.
In this particular case, when he got arrested,
Yes, 26/9.
26/9.
9. Shown arrest.
Shown arrested.
Shown arrest. Because already that time he was in jail.
And bail was obtained by him.
On 17/10,
But he was.
but actually released on 23/10. In all the cases, he was released on 23/10.
And shown arrest in this case on 26/9 and
25.
26.
sorry 25/9,
Total.
and then in the main case when he was arrested initially.
Initially, he was arrested July.
In the
I
month
think
of July.
in July.
In Lotus Hill PS case.
In Lotus Hill PS case number.
He was already arrested in a case in West Bengal. Thereafter, by on transit remand, probably he was taken here, since then.
Mr. Potter, whether after obtaining the interim bail, is there any note from the he is not cooperating? Is there any kind of thing?
Otherwise, after obtaining interim, there is no such note, on medical ground. He obtained interim protection thereafter. Thereafter, regarding that aspect, no.
No any other crime here.
Not committed any further crime.
No.
Very good.
He can assume.
So
Moza paise.
Let him face the consequences of trial. Otherwise,
yes, let him face the consequences.
14 numbers of cases, he will have to finish it.
Ultimately, he has to face the consequences. He has to face the trial.
Otherwise, only on at this point of time on medical ground also, he cannot again bid for more extension because now also what is the present health status, there is no document.
No, I'm not. Pinpoint on the
And
medical
there are
point.
Supreme Court decisions also on the in granting bail on medical ground.
Well, this is I'm not.
So that, without consulting medical board, determining the exact health status of the accused person. There are lot of decisions.
My submission is not that on health ground. I have put in emphasis.
So on what ground? You are married.
Merit means that custodial periods over detention period, custodial period,
But in that
actual
so
detention period, actual
whatever
custodial
you have
period.
already submitted that you got your interim bail on 17/10. Maybe you release on 23/10,
2010.
whatever.
But actually, I was arrested
Whether
early.
it
First
can
case,
be considered as a constructive
Custody.
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 There's no such thing.
No, even if-
Any
Even if the constructive custody, even if not constructive custody,
in that case, when it
actual
is
detention
27
27 days, madam.
Mr. Inspector and also hi. Should be what an application. City receipt because it's submitted. And his interim was granted, considering his medical, considering his health issue on 17/10/2020. and he was accordingly released on 23 Jan. Since then, he is in interim bail. Due to his medical conditions, his interim bail was extended time to time by the court. He was arrested in connection with this case on 25/9/2025, and after 7 days of his custody in the present case, he was granted with the interim, he was granted with the privilege of interim bail on 17th and Mr. Mitra submitted that initially the accused was arrested in the month of July under the notice of PS, and since then was in custody. Police got sufficient opportunity for his interrogation that occurred. His statutory period is also over, as he was arrested in this case on 25/9. The other coordinate benches of this court also consider his bail application, and considering his medical ground, his bail, interim bail were also made absolute. The submitted and accused extend his cooperation in further investigation of this case, as and when his cooperation will be needed. Next, Mr. Gauhati did an that there are altogether 12 of 13 numbers of cases against and petitioner, and initially one case was registered in Bangkok. Thereafter, several cases were registered, and in all the cases, his model operandi is also seen. He is involved in the organized crime. However, his fact that his bail, interim bail was considered on his medical health issues, but at present, the petitioner is not in a position to. The petitioner has not produced any medical document to consider his health issues. Mr. Botford submitted that may be arrested on 25/9. That cannot be considered as a constructive custody for 60 days or more for constructive custody for the statutory period, as he obtained his interim bail on 17th. The considering all these specific cases, including the fact that the accused was granted with interim bail only for his was granted with interim bail for his medical and health issues. In all the cases, he was, and almost in all cases, he was also granted with bail for the same issue. It is also seen that there is no note in the file that he did not cooperate the file for getting the interim bail. At the same time, there is also no metric in the case that he had violated any terms and conditions. So without going detail into the merit of the case, only considering the issues of the present accused petition, the present conduct of the and that custody further custody determination benefits. Petitioner is hereby directed by all conditions and also to cooperate in investigation by appearing before the I as an with the above the interim bail granted to the then. Seventeenth and 17 lakhs of 14 or 17?
Huh?
Seems to be 1710.
1710, 17.
That 1710 is hereby made absolutely simple. Here we have received.
Search sheet submitted, my lord, on this one.
Charge sheet submitted.
Yes.
Yes, Mr. Munir, charge sheet submitted.
The last order was their lordship or calling scan copy lordship.
Scan copy was called for.
All lordship. I think that it will be better lordship. We will approach the trial court.
On the last occasion, only charge sheet was signed.
I pray lordship I will appear before the learned trial court. Lordship.
Mr. S. Munir, the learned people. The learned people appearing there. Scan copy of the TCR is not revealed, just scan copy of the TCR is not yet received. And in the same time, it is seen from the order dated 4/2/2026 that case has already been charged. In that context, Mr. Munir submitted that the liberty may be given to the present petitioner to approach the learned trial court with an appropriate application. Considering the submission made by Mr. Munir, the petitioner is hereby asked to approach the learned trial court below with an appropriate application for regular bail, which may be considered in with the above observations. Okay.
Much obliged, your lordship. Much obliged.
Please, Your Lordship. The duty period is over, Lordship. Petitioner was arrested on 14 December. 14 December.
14th of December.
Yes, 2025.
It's 305E.
E, my lord. Theft
Yes,
of
I-
government property.
Okay, it's 60 days.
60.
Otherwise, materials were there.
Yes. CD receipt.
URMS,
D. Basumatari.
D. Basumatari. Third MS, D. B. Basumatari. D. Basumatari. You are appearing, your name is not here. You are appearing for MSD SOM.
Yes.
Appearing on behalf of MSD SOM. CD receipt. Already submitted by MS Basumatari that the accused got arrested in connection with this case on 14/12/2025, and thus the statutory period 60 days is already over, and in that ground the petitioner may be released on bail. However, he is ready to extend his cooperation in further investigations. Mr. Bott, the learned petitioner PP submitted in this regard that there are sufficient materials against the present petition. The fact that till even after the steps of the statutory period, the IO could not get a charge. In view of considering the submission made without going detail into the merit of proceeding. Yes, which court, which district case is from? Case is from which district?
Kamrup Metro.
Kamrup Metro.
Metro. Dispute case.
To the satisfaction of CGM company.
Kindly this matter will be fixed at 2 p.m. Obliged.
Time.
Is there not received?
Case diary not received. You are in custody since when?
13-1.
Shown
32 days.
32 days. Shown arrest.
Yes.
It has to come from which place?
Kazolka PS.
Shiram.
Chirang.
Shiram.
Yes, what when it can be fixed?
Maybe on 27. 27.
Lordship, kindly 24.
24. Can be 5. Okay then.
Another
24.
next item.
24.
Next
Same Lord.
CD not.
Same.
Out of same.
Same Lord.
I mean out of same affair.
Same affair.
Okay then 24. CD not received.
Is there received, Lordship?
Yes. Uh, 103.
103, Lordship.
Lordship.
Let not be ascertained in the PM report, Lordship. Forensic FSL was awaited in there, Lordship. They have sent, but FSL is not here.
It's already been 85 days, Lordship.
Because last seen theory, because the accused Lordship, Ikramul Haq Lordship, he was the Sardar of a brick industry. Lordship. Then he have taken the deceased with him. Then that day onwards, he was missing. Lordship. Then they have filed a missing FIR, and ultimately, they on the next day, they have received the dead body near the brick pit, brick
With
industry.
some
Lordship, in a
injury
paddy.
marks.
There were injury marks, Lordship, but the cause of death is not detected, Lordship.
Lordship, as per the FIR, it is mentioned that he has taken the deceased victim, but accordingly, Lordship, once a week he visits the brick factory, and the FIR was filed by one of the uncle of the deceased victim, who was not even working as a worker under him, nor he was present at the time. And his the deceased
Oh,
victim,
everyone saw you while taking the deceased
Deceased,
rescue, na?
along with
Along with
father, mother.
Lordship, the deceased victim parents were working under him.
yes.
Uh,
Working under him. So you were Sardar.
Yes, Lordship.
Being a Sardar, you took the boy. That is the allegation. I'm not
Yes.
saying otherwise. Directly, most probably there may not be any direct evidence, but all are
Last seen theory is
or
there.
last seen theory. But the now question is that he is on 85 days.
85.
So what do you want to say? Is there any probability of submitting charge sheet within 4 or 5 days? That is to be considered. Otherwise, 85 days he is in custody.
Lordship, moreover, the FSL is not there because the cause of death could not be ascertained through the PM report, Lordship.
So may I may
Lordship,
not be in a position.
Today is Friday. Let it be on Monday if FSL or I could not produce.
Question is that whether within 4 or 5 days I will be, it will
Lord,
be
that is
possible
there,
to be
Lord.
part of I.
Already 85 days over, Lord.
Lordship, length of detention, Lord.
Otherwise, there are materials.
Only last seen theory, Lordship. That father, mother of the deceased, Lordship, they have given the deposition, and one witness also, Lordship. complainant is the uncle lordship and father and mother is their lordship. 161 is there that he came and have taken the son with him. And from that day onwards, he was
He
missing.
was missing.
And immediately the next day, they have recovered the dead body from the paddy field. It is 1 kilometer away from the big. That much.
Lordship, I was called in the police station to identify the body. I went there. There I was arrested. I was not even absconding at that time. On 21, Lordship. And numerous times I visited the police outpost, Lordship, to know the whereabouts.
Repetitions. RMS. A big Tilane it's an application as however, it is submitted to MS Begum that a cause of death could not be ascertained as the accusation is still awaited by the IO. The case is still under investigation. It is submitted that there are materials against the present petitioner, who was the Sardar of the brick factory, and the last scene, and there are circumstantial evidence against the present petitioner, especially the last scene is up. However, she submitted that due to non-receipt of accept, the IO is in a position while the charge it, and there is penalty and probability of filing charge it with next. Mr. Rahman, the current counsel, that he was never absconded after the recovery of the dead body. Rather, he was called in the police station, where he also identified the dead body of the victim, and then only he was arrested. He further submitted that prior to the recovery of the dead body also, he visited to the police outpost in search of the victim, deceased, and he had never committed any such offense as a resident. However, the accused petitioner is in custody more than 5 days, hence considering his length of detention, his prayer may be considered. Accused being the permanent resident of his address locality will cooperate the IO in further investigation of this case, and there is no chance. If considering the submission made sorry, case diary and case diary. It is the fact that the IO is not in a position to submit the charge sheet as case is still under investigation and the FSL report is still empty. The accused petitioner is in custody since last 85 days, and hence, considering his period of detention, I find that the IO got sufficient opportunity to interrogate him, keeping him in custody. Accordingly, without and hence without going detail into the merit of this, only considering the length of detention and that part the detailed interrogation may not be for the. It is a case of which district?
Oregon.
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 This is CGM. Your country.
Highly obliged.
I know realize yesterday on it, public question says my lord. Charges has been submitted, my lord. Your lordship has directed him to ascertain.
Look here, charge sheet submitted, my lord. We have verified, my lord. I charge sheet number 30 of the 26. Let us
Why can you call for the my lord record from the said
What
because
is the case? 30 only?
26, my lord. Dated 30126.
Okay, wait, the petition of Mr. Bishop. Submitted by Mr. Sharma that case has already been treated.
Then you also
Right.
can call for a record, my
CS
lord.
number POP 26 dated 30/01. In view of this, Mr. Ahmed, the learned counsel petition submitted that the scan copy of this year may be called for. That would be let the CDV scan copy of the PCR along with the case diary be called for. The learned trial court below. Registry will include in it list matter according to the month of March. Will do 13th of March.
30, 30.
1
Oh, well, all right.
In this matter, probably charge sheet has been submitted. I do not know, but it's a very old matter, my lord. Petitioners are also in interim.
The court.
Okay.
They also CD not received to them. After that CD
No,
was called.
charge sheet may be submitted here.
Then I will have to take it.
No, I'm saying as Mr. Das is submitting
Probably নাজানো, মোৰ ভাবিছোঁ বহুত পুৰণা।
because the order was passed on 7/8/2025. Oh no, the AB was filed on in the month of May
Interim granted on
2025.
indemnity.
Month of May 2025.
Interim
And
granted long
then interim was granted on 7/8.
7.
7.
Bail file on 19/5. 19 May.
Very old matter.
Old man. Let them take instruction, man. The date may be fixed.
Fine.
Heard Mr. S. Das, the learned counsel for the petitioner, also heard Mr. Bishop. It is submitted by Mr. Sharma, sitting seat. Mr. Das, the learned counsel for the petitioner submitted that it's a very old matter and for his information, the charge sheet may be submitted. Being this submission made by learned counsel, petitioner PP is directed to take instructions in that regard as to whether the charge sheet has already been submitted. Let the matter when it can be. You just take the information.
Pandemic. What is it?
Put list
Last
lots
week
of matters.
last week of February. After 20.
26 May.
26.
And
And we also call for calling
Minor,
for case diary to
minor.
this
If
year,
charge sheet not fine, 26.
26 to road. In the meantime, CD may also.
Highly obliged. Highly.
Interim be continued till next.
May I please your lordship? CD yet not received. Or charge sheet has not been. 35. CD not. Interim order passed on 29/10. Maybe continue.
CD not issue reminder. When it can be listed.
Minor it March, minor 5th March.
50 lots of matters have been picked there.
Then next to minor 10th March.
Maybe on that.
Okay.
10 trees to and so
Right.
interim be continued till next year.
Of course. There also in this case an additional affidavit has been filed with us to bring into record certain facts in regards to the petitioner number 1 and 2 were granted interim, and they have been they appeared before the concerned police station within the 7 days, 4 days, and thereafter as per the direction of the court, the statement of the petitioner number 1 and 2 are not being recorded till date.
Minor here charge sheet submitted minor as per information.
Charge sheet is submitted.
My
Minor.
lordship may call for the LCR, your lordship, and
Charge sheet submitted. Yours is a AB only.
Minor.
We are extending your
Yes.
thing.
yeah, your lordship.
Thereafter, if your anything is adverse order is there, you can approach this court. ABY will pen
Yes.
the AB only. Case has already been charged. You are Mr.
Yes, ma'am.
S. Amit. Mr. S. Amit. The learned counsel for the petitioner also had distributions and so forth. Yes, what is this CS number?
My lord, charge sheet number 270 of 25, dated
270 of 25,
dated 29/11, 25.
29/11.
My
Then how many days? Earlier you were granted interim material
Yes, sir, for 1 and 2.
for 1 and
For 1 and 2. While order dated 18/12/25.
18/12. And so you have this the interim for the petitioner number
Both.
1 and 2, namely Omina Begum Elias and Abu Shahid, the extent. And all the petitioners are hereby directed to appear before the learned trial court below within the appropriate effects of it within 15 days from the date of order, which may be considered. So you are directed to appear within 15 days from the date of order, and the petition number 1 and 2's this interim bail we are extending till 15 days. Yes.
On the previous date, madam, the instruction was sought for from the as to whether any affair has been registered in this case, madam.
Acha, acha.
Here today we have not received any information, man.
Report is not received.
No.
And petition is on the interim, madam.
James,
Hard Ministry of the learned distribution report see issue reminder interim be continued till next list accordingly when it can be listed.
in the month of March, man.
Yes, so 12th of March.
Interim may continue.
Yes, we are continuing.
Right. Hello.
Please, Your Lordship. Application 482, Your Lordship, PNS says in this case, 16 petitioners, Your Lordship, all are family members.
16.
16, all are family members. Page 11 is the affair.
Yes,
Page 11 is the affair, Your Lordship.
yes,
Right.
yes, FIR.
With due respect, I requested that on last 13/10/2025 at 4 p.m. in absence of other family members in the house, the below mentioned accused number 1 called my younger brother Norshad Ali from his residence to accompany him to here, Ashtabahar, Vishwahari, near their residences, and when they reached in a paddy field, a group of about 30 people, as per their earlier conspiracy, attacked Norshad Ali with lathi and grievously injured him. Moreover, the accused persons with an intention to kill Norshad Ali grievously injured him with sharp weapon. Then some local people arrived in the place of occurrence and found him in a serious condition, and thereafter they took the Norshad Ali to the civil hospital with a vehicle. But the doctor referred him to Gauhati for better treatment. Thereafter, he was admitted at PK Shah Hospital, Coachbihar, but it is not recovered till today. Fact is something different, Your Lordship. I have paragraph 4. The victim, Norshad Ali, deceitfully taken away the wife of petition number 3, Rofika Bibi. And after 2 days, the villagers, nearby villagers, found them and then physically assaulted the victim and intimated the petitioners. And then petitioners number 2 and petition numbers 3 and 4 arrived in the place of occurrence and taken back their wife, Your Lordship. After that, the instant affair has lost. Instead, is some allegation that he was taken cold and physically assault. Actual fact is not mentioned in the affair. And all the family members, they have implicated in the affair because though they are not present in the place of occurrence, wife of the petitioner number 3 is taken away by the victim. And after 2 days, the nearby villagers found them and got red-handed and physically assaulted and intimidated them. This is the case.
Regarding the injury, Lordship, there is swell over right leg, then lacerated wound over right leg, and Lordship, tenderness and swelling is there and peritoneal reason. And the opinion is not there whether he's serious or some simple injury or grievous. It is not like that, Lordship. And Lordship, one thing is that the victim could not be examined in the city, Lordship, as his mental state is unstable. Moreover, the victim does not recognize anyone and is unable to answer a question asked to him. It is also noted that the victim is suffering from hallucination, delusion, erratic behavior, and self-harm. That I am not get it, Lordship. These are the things with the victim. And regarding the injury part, Lordship, not so serious, Lordship, as it reflects on
No,
the-
rather I would say it is serious because if it's under hallucination, irrelevant talks are there.
No,
So-
no, and that is, for that I have submitted that, Lordship, his mental status. In physical side injury, I am saying that, Lordship, according to report, Lordship, there are, Lordship, the
In parietal region, there is injury, I think.
well, Lordship,
In parietal region,
Lordship, tenderness and swelling over it, and parietal region, and leg injuries. He was injured in all parts of the body, but it is not mentioned whether it is grievous or something like that, Lordship. Only tablets were prescribed to him, medicines prescribed, Lordship. And cut injuries also in the right leg, left leg. Then there is also vomiting. But doctor have nothing, Lordship.
As per my instruction, he is treatment in private hospital in Coachbihar. As per my instruction. So all the petitioners are not present there. The nearby village man, after 2 days, found them. Wife of the petitioner was killed.
this part is for this injury, and what about the other ingredients? Is there any?
Witness
Weaknesses, Lordship.
independently.
And what about the other?
Moreover, your question number 9 to 16, the learned trial court below granted interim, they already cooperated appear before the IO. 9 to 16, 8 petitioners, they
We are not for 9 to 16.
no order. I am for 16, total 16 petitioners.
So you are saying 9 to 16.
No. Initially interim granted, but subsequent after receipt of CD, it was rejected. And it could below here. They already appeared before the IO. After
Why
receipt
is
of
the rejection order?
rejection error, your lordship, page 18. They approach the learned court below. Petition number, petition and request same, 9 to 16, they approach the learned court below. Initially granted interim, but after receipt of case diary, interim was vacated. That's all.
Lordship, the witnesses are incriminated all the accused persons. Lordship, I will read one, Lordship. Statement of witnesses. Sakhatun Bibi, Lordship. My name, address, so and so. I came to my father's house at Moragodhar Sor few days back to stay for some days. On 13/10/2025, we, the villagers of so and so, sir, were enjoying a musical show which was going on at the paddy field near the residence of Kanimuddin Sheikh. Then around 4:30 p.m., we heard people screaming and abusing. Then we saw about 10-15 persons assaulting Nosad Ali. We all went to rescue him, but the accused person were carrying lathis and warned us not to come close. I saw Irfan Ali, Izadul Sheikh, Sanwar Ali, Marizuddin, Ahidur Ali, Shahjamal Haq, Shahjahan Haq, Nazrul Haq, Nur Islam, Ainal Haq, Hafizul Haq, Mafijul Haq, Jehuso and all lordship, all of them hit Nosat at a selected target so as to inflict grievous injuries to him with an intention to kill him. They targeted his head, limbs, and private parts, due to which he was badly injured. But still, we somehow managed to rescue him from the furious crowd and immediately took to Dhubri Hospital. He was then referred to GMC for better treatment. In the same manner, Lordship, one another witness is there. The witness of Minarul Haq, Lordship. He have also named all the witnesses, Lordship. Same. Then, Lordship, one is there, Lordship. Abu Bakr Siddiq. And he have also implicated all the accused, Lordship. All, Lordship, all witnesses have implicated. Assault was there, Lord. Assault was there. And injury was also there. Then his mental status is also reflecting that recognized.
In deceitfully taken, illicit relation taken with the wife of customer 3. Then they
There
found
is no such thing, sir.
That is not reflected. Only it is that he was
It's
All the others, there are some independent witnesses are also there.
image
But they have
witnesses,
not
they are
reflected that story.
independent or not, they are the same villages.
Independent witness.
Independent.
They are
They have
same
not
village.
said. Same village, independent witness, maybe from same village.
Maybe they are relative. There's no inspection after 3 days, 10 to they were led away, wife of Christmas 3 and found them on 13-10. 10-10-25, Northside Ali is taken a wife of Krishna 3 Rohika BP. And after 2 days searching, they found on 13-10 villager. Not only villagers found and they intimidated them, then they had to be killed.
It is submitted to some villagers no. No, it is a case of the petition that the victim shot the wife of the petitioner number 3, and after 3 days the village people got them red-handed, and thereafter they assaulted him and also intimidated the president. Immediately the petitioner number 3 and 4 visited there and rescued the wife of the and if any injury is sustained by the victim, that is only for the assault made by the villagers after the said incident. However, all the petitioners belong to the same family and and they will extend their cooperation if further investigation is necessary, if they are granted with the privilege of the arrest. Ms. Begum, the learned additional PPs that a medical report has seen that the victim sustained injury, especially the head injury. So there is no specific concern about the object by which injury is sustained, but not only, but he sustained multiple injury all over the body for the same context. We further submitted that some of the witnesses also uttered the name of all the petitioners, showing their involvement in the alleged crimes. MSB, accordingly, raised objection, submitted that this is not a case for previous bail, and their earlier bail application was also rejected by the learned trial. Hearing the submission made by Rani Counsel. I have also verified it. Considering all the aspects of the case and the materials from the case diary, the custodial interrogation cannot be necessary. The interest of the investigation body and take the case to extend privilege periods to all the petitioners. Okay, again.
Bless.
Lordship may not be, I was told it not inclined to be not taking special bench, Lord. So can it be on 19th of this month, February, Lordship?
19th.
19th of February, Lord.
In that case, we are not going to mention for appropriate bench, we're simply listing on 19th.
19th. Lord.
Request made by Mr. Alia, the Learned Counsel for the petition. Date the matter 19, 19-2,
19th,
this
Lord.
month. Oh, 19. We're listing it on 9.
I'm okay. Maybe to mention item 46, my lord. 46. This matter may be, my lord, adjourned today, my lord. Please.
But why Mr. Boro is here? No.
I have already contacted the senior. They have no any objection.
Inform them.
Yes, no, they have no any objection.
Acha, acha. You are with Mr. Boro.
Yes.
He is seeking bail. What is the stage of the case at present?
Appearance stage, my lord.
Still at the appearance stage.
Appearance stage, my lord. Because one is absconding accused, my lord.
One is absconding.
Absconding.
And what about you? You are appearing?
Yeah, next date is my lord on 23/4/26, my lord. On that day he will appear, my lord.
With the consent of the others, the Learned Counsel for the Mr. Deep Singh, the that will be accordingly.
After my lord 23/4, my lord.
You will see. He is appearance date is on
Appearance date is 23/4.
23
4 April.
April.
April, my lord. 25.
Not April or can it be possible? Do you have any objection in that case?
No.
20? 28 of it.
Deeply obliged. Deep.
Item 3-0.
May it please, Lord. I'm sorry, my lord, I could not attend in the first call, my lord.
It's okay.
But FIR, your lordship will find at page 10, my lord. Last occasion, my lord, Chidi was there, my lord, but postmortem report was not there, my lord. Therefore, my lord, lordship has fixed the matter today, my lord, calling for the PM reply again.
Postmortem report received, my lord. Opinion, but cause of death is, my lord, opinion regarding cause of death is not conclusive, my lord. Opinion regarding the cause of death is kept pending until the receipt of chemical analysis report from DFSL Kahilipara. It is there.
Here I am finding one thing.
Yeah.
Suppose if any suspicious condition
Yes,
is
ma'am.
there, suppose poison is there or he
yeah.
was dying, in
Yes.
that case, a viscera or other organs
yes.
may be sent to FSL. But in every cases I have seen that why for need of every cases to send for FSL?
Yes.
If it is suppose the other marks is there, the other thing is there, then in that case too it can be
Your lordship,
no, it can be, I mean, postmortem, the opinion also can be,
Yeah.
it is kept open again for the FSL, and in some cases we have seen that in spite, even after the furnishing of your charge sheet, the same is still pending for the, that creates a problem in fact.
Yeah.
Otherwise,
here case is registered under section 108.
Abatement to suicide, my lord. FIR, your lordship will find at page 10, my lord.
108 is
108, my lord.
yes,
The
Mr.
present
Bora,
petitioner,
we
this
are
is
going
BA, my lord.
pardon?
And regarding, this is BA, my lord. Petitioner is in
And
jail
custody for 28 days, my lord.
16-1.
28 days, my lord. Here, my lord, FIR, your lordship may kindly see first, my lord, at page 10, my lord.
Oh, it is a 108.
108. But
Oh, acha.
Yeah, I have perused the case diary, but from the case diary, my lord, this is my lord. She was in living relations he was in living relation with one Brazil to nursery, and she was in fact my lord living with him my lord at the time of my lord commission of the my lord suicide my lord.
That is my another accused, my lord. I am not, my lord, that for Narjari, my lord. I am Pujalam, my lord. And so far, my lord, last occasion, my learned friend Samir, my lord, the deceased was last seen with my lord Pujalama, my lord. It's a my lord case of my lord abatement of suicide, my lord. So my last injury, my lord, my humble submission may not be my lord at, necessary for this case. Page 10 may kindly see, my lord. Chair, my lord.
Yes.
Married, my lord. With due respect, it is stated that Faza Basumati, aged about 20 years, date of birth 03/2005, is my daughter. She was residing in Bongaigaon and pursuing her nursing studies there. Today, on 15/1/2026, at around 7 a.m., she left our house stating that she was going to Bongaigaon. The said part is that today, at around 11 a.m., my daughter-in-law, Srimati Archana Basumati, received a phone call on her mobile from a male person using mobile number Sessions, who informed that Faza Basumati was attempting to commit suicide in her room. That thereafter, at about evening time, the police personnel from Gosaigaon Police Station called me over phone and asked me to come to Gosaigaon Police Station. Accordingly, when I reached Gosaigaon Police Station, I saw the dead body of my daughter Faza Basumati. That from the above facts and circumstances, I have a strong suspicion that the person mentioned below are involved in the death of my daughter. Here, suspected person, my lord, Brazito Najari, my lord, and my lord, second is my lord Puja Lama, the present prisoner before this court, my lord. And as per on the basis of this FIR, my lord, the prisoner was arrested, my lord, on 16/1/2026, my lord, as on date, my lord, 28 days in custody, my lord. Yeah, my lord, your lordship knows, my lord, in a case of my lord abatement of suicide, my lord, the suicide must be, my lord, in such a degree, my lord, leaving no option to the victim to accept to commit suicide, my lord. And moreover, my lord, the active participation of the my lord accused is also, my lord, equally important. My lord. So.
What is your case then?
Lordship, my lord, that is true, my lord. On the date, my lord, I met her, my lord. But so far, my lord, suicide, my lord, there is no, my lord.
So
I have no.
how you know her? Who are
Lordship,
you?
my lord, from the my lord, she was pursuing nursing course, my lord.
These are okay. Now, who are you and how you are connected with the girl? Deceased?
My lord, she was my lord, friends, my lord,
Your friend.
friends, my lord. Both are my lord.
And then it's okay, a friend, you met her then. What happened?
My lord, she and rest, my lord, CD, my lord, on last occasion, my lord,
No, my question is whether you found her to commit suicide.
No,
Like
my lord,
that's the step.
no, my lord, I have no knowledge, my lord, of what is going on in their life, my lord. And my lord, so far, my lord, abatement is concerned, my lord. Is there any material in the CD, my lord, how, my lord, I have abated her to, my lord?
Yes.
Well, yes, at the time of before committing suicide, my lord, Puja Lama, the present petitioner, was from the statement of witnesses. She was seen along with the my lord victim, my lord. That is there in the statement. Regarding otherwise, my lord, regarding torture, my lord, otherwise ingredients of 108, my lord, from the material still now, my lord, there is no only she is a suspect. My lord. Till otherwise, my lord, the victim was last seen together along with the present petitioner, my lord. And how, my lord, actually, in fact, how the present petitioner is, my lord, connected with this case, my lord, regarding from the case diary, my lord, those things not comes out till now. Later on, my lord, if something comes, my lord, no, my lord. But till now, otherwise
The person that one person over telephone.
yes,
Informed another daughter, that is the Archana
yes,
Sumatari, that she is going to commit suicide. So how he can know at that time why he
because
did not?
my lord, at that point of time, maybe my lord, who has called the my lord family of the my lord victim, that is also not specific in the CD. But one fact is clear that the victim person was my lord. She is at the time of at the time of committing suicide. She was in a living relationship with one Brazil donor for last 1 month, and there is dispute between them, my lord. frequent dispute between them, my lord, regarding that, my lord, statement is there. Otherwise, how this Puja Lama, my lord, came into picture, my lord, regarding those materials, although she is a suspect, my lord, that she is also involved in, my lord, harassing the present petitioner. But regarding other materials, how these things are not, my lord, there in the case there.
Mr. Keyboard regarded also heard Mr. Keyboard regarded CD receipt submitted by Mr. For the dependent to the DLS. However, it is affected on the day of incident she made her being as the deceased was then, and that apart, he has no knowledge as to how why the victim of the deceased committed suicide. The present accused petitioner got arrested in connection with this case on 16/1/2016 only on suspicion, and since last 28 days she is in custody, and hence considering her period detention also, she will be released. She will abide by terms and conditions of the bail, and will also extend her cooperation in the further investigation if she is provided with the privilege. Next, Mr. Bott, an additional PP submitted in this regard, that it is the fact that the victim was last seen with the deceased, but thereafter there is no other disclosure in the statement made by the witnesses. Rather, it is revealed that she had a living in relationship with accused number 1, Brazilto Andrade. However, Mr. Waterford submitted that during the course of the investigation may come how the present petitioner is also associated in the said office. Next, hearing the submission made by that and the materials in case record, and also considering the length of detention for the investigation, and that further custodial interrogation may not be required for the interest of the investigation. It is from case from which place?
My lord, Gosaigaon, my lord, SDGM Gosaigaon.
SDGM goes. SDGM bracket M like you said.
Right. May I please, your lordships, in this case, my lord, as in
You have
compliance
received here case
of the order, yes, my lord. In compliance of the order passed by this honorable court, my lord, is in interim, my lord, all the petitioners, my lord, the same family members have appeared.
How many petitioners are here?
Almost 5 numbers of petitioners, my lord. All the brother and the father, same family member, my lord. And the informer side is also the relative, my lord. The incident arising, my lord, out of a dispute, land dispute in between both the parties, and dispute has not yet to be settled, my lord. And my lord, as per order of this honorable court, the petitioner has already, my lord, appeared before the, my lord, investigating officer, my lord, and recorded their statements. And now, still now, they are cooperating, my lord, with the agency, my lord, investigating agency, my lord. And my lord, the other facts, my lord, that, my lord, there was actually, my lord, on the very day, my lord, at the first instance, my lord, we have lost FIR, my lord. We have lost FIR, my lord. But our FIR, my lord, not has been registered, my lord. Not registered. But their FIR registered, my lord. On the same day, both the parties have, my lord, lost their FIR, my lord. Kindly have a look at page, my lord, at the FIR, my lord, in which you were accused, my lord, in page 13, my lord. Page 13, my lord. 1-3. These FIR, my lord, lodged by Alfazuddin, my lord, the relative of the accused petitioners, my lord.
There's a long FIR, my lord. May I read, my lord? Yes.
It's okay. So that
But out of
your
my lord,
FIR was not registered.
our
So
FIR
who
not
sustained,
registered.
who
I have,
sustained injury in that case?
yes, my lord.
Who sustained injury?
My lord, in our case, my lord, we have sustained injuries, my lord. In informal, my lord. In our case, my lord, in Habibur Rahman, my lord, sustained injuries, my lord. And in that case, my lord, in their case, my lord, in that case, one sustained injury by Saddam Hussein, my lord, son of the informant, son of Alfajuddin, my lord. And others, there was, my lord, minor altercation was there, my lord. And out of their altercation, both the parties have sustained some minor injuries, my lord. And my lord, this incident, my lord, arising out of, my lord, on the alleged day of incident, my lord, while the, my lord, informant, my lord, informant and his family members have engaged, as per their affair, my lord, engaged Mizanur account and Saddam account were cutting big trees lying on my Mehdi land, my lord. That, my lord, the informant side were cutting the big trees in the disputed land, my lord. Then the petitioner, my lord, petitioner number 1 and other petitioner, my lord, prevented them that do not cut the trees till the disposal of the dispute by the villagers. Already that dispute has been placed before the village head, village headman and other village elderly persons of the villagers and their relatives also, my lord. But that has not been settled. That's why they have prevented, my lord. At that time, my lord, while they were cutting trees, and one of Saddam Hussein fall down from the tree, my lord, along with Dao. Then sustained minor injury. My lord?
That is their person, my lord. That is whatever.
Some might have some sustained minor injuries, my lord.
Let's say, may kindly produce the medical report, my lord. And 2 fractures are there, my lord, and it was in the head also. And last 2, my lord, there fracture, my lord. And it was operation also was done as per my lord, informant and GNRC also. And some of the witnesses said that he is in ICU, my lord, in lower hospital, my lord. Please call for it. Lower Assam Hospital, Bongaigaon. He was in ICU, my lord. And one important thing is that, my lord, after interim they have appeared statement recorded. Let's may kindly pay the statement of the Habibur Rahman. He is the person who assaulted the, my lord, victim, my lord. Let's may kindly pay his statement.
Habibur.
Habibur. In his statement, he said that he has already decided to kill the, my lord, the informant, son of the informant.
My lord, that is, my lord. There, as per their affair, Habibur Rahman suddenly trying to, my lord, as per their affair, my lord, that is at page 14, my lord. As per their affair, they have stated in the affair that Habibur Rahman suddenly trying to assault on the head of my son.
How he
Trying
is
to.
How he
Trying
is
to. But my lord, he has actually that Saddam Hussein, while cutting the trees, my lord, it is admitted in their affair, my lord, while cutting the trees, he himself fell down from the tree, my lord, on the ground, my lord, from the tree. From the upper part of the tree, he fell down on the ground, my lord. As a result of his sustained injuries, my lord.
victim statements are injured.
Is injury part whether that is sharp weapon or not? My lord, in this case, my lord, the actually as per section, my lord, 118 subsection 2, my lord, that is, my lord, if any grievous hurt, my lord, that is to be caused by, my lord, knife, sword, firearm, fire, poison, acid, explosive, etc., etc. But the cause of, my lord, that injury by which weapon, my lord, that is to be, my lord, ascertained, my lord, and particularly, my lord, out of all the accused persons, my lord, particularly only one Habibur Rahman, his name has been mentioned as trying to assault, my lord. Then, my lord, other persons are not, my lord, in there, my lord, except, my lord, your lordships may consider other persons, my lord, family members, my lord, as my lord, they are, my lord, cooperating, my lord. There is no chance of, my lord, absconding, my lord, and they will till, my lord, the completion of investigation, my lord, all the petitioners will, my lord, fully cooperate, my lord, fully cooperate, and they are, my lord, relatives, my lord. There is, my lord, other petitioners may be, my lord, considered, my lord.
But Mr. Bishop, it is submitted by Mr. Ahmed that all the accused petitioners appear before the IB after obtaining the pre-arrest bail on 20/01/2026, and the statements are also recorded, and they are still cooperating in the investigation. We further submitted that there was a land dispute between the parties, and on the day of incident also, there was a quarrel and scuffle took place between the parties, but there no such incident took place as alleged there. For the said incident, they have also lodged an FIR the first instance, but that was not registered, and the FIR lodged by the informant had registered and investigated. He further submitted that the sum of the persons from the petitioner side also sustained injuries for the said victim, but the case was not registered by police. He further submitted that as per FIR, only one accused petitioner, Habibur Rahman, tried to assault the victim Saddam, but there is no clear statement as to whether he gave any blow with any sharp object to the victim. Rather, the victim sustained injury by falling down from the tree while they were cutting some big trees which were in the disputed land. However, all the petitioners are ready and willing to extend their cooperation in further investigation of this case if they are granted with the privilege of defense. Mr. Sharma, the learned additional people submitted in this report that there are sufficient materials in the case diary, and the injury report also is seen that the victim sustained grievous injury who had to be admitted in ICU in the hospital of Lower Assam Hospital in the Lower Assam Hospital. From the witnesses also it is seen that that all the accused petitioners are involved in the arrest, and especially the petitioner Habibur Rahman also stated before the IO that his intention was to kill the victim. Mr. Sharma accordingly raised an objection and submitted is not at all the case. Explained the privilege of pre-arrest bail to the present case. May be sufficient with bail is that to be witness is that saying that scuffle and altercation with the parties. But these petitioners took active role in assaulting some of the victims. However, considering the methods available in the case diary, the prayer for pre-arrest bail is considered for the accused petition number 1, 3, 4, and 5, and the prayer for pre-arrest bail is hereby rejected for the petitioner Habibur Rahman, that is the petitioner number 2, Habibur Rahman. In view of this, the bail interim pre-arrest bail dated 20/01/2026 is hereby made absolute for the petitioners, namely petitioners namely one petitioners number 1, 3, 4, and 5, namely so and so, so and so. However, the prayer for pre-arrest bail, he is hereby made absolute with same terms and conditions. However, the pre-arrest bail prayer for the petitioner Habibur Rahman is hereby rejected at this stage, and this interim bail order dated 20/01/2026 is hereby rejected.
Obliged, my lord.
Others, where is
Accept, my lord.
except 2, Habibur.
My lord, obliged, my lord. Much obliged.
40. 42,
May I plead your lordship?
41. Who is it? Oh, 200. B 191. What? 42. Yes.
May I plead your lordship? Lordship 482 application under section 311 BNS, my lord. My lord, in this case, my lord, petitioner, he is not in FIR name accused, my lord. FIR name accused is, he has already gone on bail, my lord. This order is, my lord, I have annexed, sir, my lord, page 15, my lord. And in respect of this case, my lord, large number of persons, my lord, police arrested, my lord, and everybody has gone pre-arrest bail, my lord. All orders I have annexed here, my lord. And why police searching me, my lord, I don't know, my lord. No way I connected both the petitioners, my lord.
My lord, here I have received the case there, my lord. And this is the case where the judge of the CBI, my lord, in the Sanmari, where his house, my lord, it was done, my lord, robbery was done, my lord. Therefore, it was done in the house of my lord, Judge CBI, my lord, Sanmari, after 2-3 months before, my lord. And here, my lord, before going to the merit, my lord, two of the accused persons, my lord, bail application was already disposed of by the court judge, the Pranjal the fund plus, that whether that matter will go to their, go to this court.
I don't know, where's Borwa? Out of same FIR, 2-3 petitions are already been disposed. আমি কিভাবে dispose করছি? Every matter is disposed by justice. It were all disposed of means allowed or rejected or what?
Allowed, yeah, that were allowed, yeah.
I have annex, my lord, here, my lord. Annex D is E also, my lord, page
Yeah.
25.
শোনাবই না লাগে। He is present here. তো পেপার কাকু দিব পারে। আপনার বেঞ্চ থাকলে বেলেগ। ক্লিয়ারিফাই হ'ব বোলে আমাৰ চেষ্টা কৰি দিলে আমাৰ অসুবিধা হৈ যায়। কাৰণ কি হয় বেলেগ নাই ভিউজবিলাক বেলেগ বেলেগ দেখা। ভিউজবিলাক বেলেগ বেলেগ হ'ব। সেইটো কাৰণে কৈছে যে same matter should be এতিয়া নোৱাৰে আপুনি বেলেগ। বুজি পাইছো। চিংগল পেজ দি আছে না। Instructed from the bench, in fact, that as Miss Justice Das is taking, most probably he is in division bench, not sitting singly. That may be the reason why this is posted here. But also same.
But yesterday also there is quite single bench was there.
Yes, he is sitting singly also, I think.
Today,
And as per roster, he is not having single bench, but single bench is there.
single bench is there.
I was been informed. He is sitting singly also.
Today also part there is single bench.
Oh,
24 is there.
single bench is there.
Minus.
Because what I'm saying that the opinion may be different as of, in fact. So yes, granted bail, this court may not grant it also bail. We cannot say at this time. So that is it.
But if lordship, my lord, I have gone through the record, my lord, if lordship. Yes, so.
Then we're taking up the matter. Yes, where is the FIR?
212, my lord.
FIR 12, my lord. Particular matter.
Oh, acha, PC Das sir.
My the house.
The case of 311. Robbery or dokaiti with attempt to cause. Your petitioner and the other accused persons were
Go on bail, my
AB,
lord.
BA.
BA, my lord.
These are all
BA, AB also, my lord.
AB also.
FIR name is also, my lord. I have annex, page number 15, my
Just
lord.
tell us AB. Where is there any AB?
AB.
Other accused persons, my lord, go on BA, my lord.
They are on BA.
BA, my lord.
But my lord, in the FIR, my lord, name is Sri Pashan Ali, my lord. Petitioner name is not there, my lord. And all others are go on.
FIR, who is identified in FIR?
Name
there
is
any
mentioned, my lord, page 11, my lord.
page?
11, my lord.
Not identified, my lord. They are the workers in the house, my lord. That house.
Contractor, namely,
House, my lord.
second
They
para,
have
my lord.
suspected that that may be involved, my lord.
Acha.
But here, which in a
Personally was the contract.
Here the present petitioners are defined manner. Shah Alam Sheikh and Mohidul Islam. Question or
Yes, you can submit, yes. You're submitting that some of the co-accused persons have already granted bail,
My lord,
number one. Number two, he is not the FI named accused.
my lord.
And number three, that name of one personally is mentioned, who was contractor.
Right.
So your petitions are not involved. Can you tell us one more thing, whether your petitions are earlier involved in such kind of offense?
No, my lord.
No. As per your information, no.
He is a Rapido rider, my lord. No way connected in this case, my lord, also.
What to do? Rapido, everyone is involved.
Both the petitioners, my lord.
Pardon? Yes, yes.
Both the petitioners, my lord.
They
Petitioner.
are Rapido driver.
My lord.
Yes, sure.
My lord, here I have received the case there, my lord. And from the materials case there, my lord, it reveals that the Shah Alam and Mohidul Islam are the prime accused, my lord. And they are the prime accused. They have planned and executed the dacoity, my lord, along with the other person, my lord. And regarding the earlier involvement, my lord, Shah Alam and Mohidul Islam are involved in previous dacoity also. And from the statement of the my lord, ultimate caliber is only one statement, my lord. How they have planned, my lord. How they have planned and executed, my lord. Only one statement is sufficient, my lord.
No, you can read.
My lord.
You can read also.
Long, my lord. One statement.
So they are the prime accused.
Prime accused, they are the my lord. How they have entered the house, my lord. How they have follow up, my lord, their conduct, my lord. And divided the ornament and sold it to the different person, my lord. Money was also divided among them, my lord. Some get 8,500, some get more money.
And they targeted the
Judge.
judicial officer also.
Judgment.
Judge.
CBI. Also CBI judge.
CBI judge. He's not Rapido.
My lord.
And Rati is
My-
kind. That's why this laborer and this secretaries are all because they know the
No.
what is the boundary, how many
What
doors
is
are there,
happening
how
with
it
the-
can be, how many family members are there, they know everything.
All the information is given.
heard MS, your name, oh, Al-Wajidan, my lord. MS Al-Wajidan, petition. And also heard distribution, this is an applicant. It is submitted by MS Wajidan that the present petitioners no way connected in the list office. They are the Rapido drivers and they are also not the name accused in the. One person was suspected in the FIR whose name is Ashar Ali, but these two petitions are connected with Said Ashar Ali, Hassan Ali, and Hassan. They 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 are falsely implicated in this case and police is searching for them, for which the present anticipatory bill has been filed by these two petitions. However, they are still ready and willing to extend their cooperation in the further investigation of this case if they are granted with the privilege of being arrested. MS Budgeter further submitted that some of the accused have already granted bail by the coordinate bench of this court. In considering the case of the present petition, the same footing, the prayer for their prayer may be considered. Next point. Mr. Sharma, the learned additional people submitted in this that there are sufficient incriminating materials against the present petitions and who are the prime accused of the case. The plan for Dakati was they planned for Dakati for 20 days ago till the from the commission of the offense, and from the available materials in the case record it also reveals that how they planned for commission of the offense and how it was executed with the help of the other co-accused. Mr. Sharma raised objection and submitted that the entire docket was also committed in a former CBI charge from the part of the city that is from Chanmari, and these two petitioners are also involved in many other cases. According their custodial interrogation will be required for the recovery of the articles as well as for as well as to apprehend the other culprits in this case. Next, considering the submission made by the case diary and considering the materials available in the case diary, statement made by the witnesses as well as the accused person, it is seen that these two accused persons are the main the prime accused who executed the plan of Dokati.
Plan and executed
the Dokati and everything and the which is revealed from the case diary. Considering also considering the nature of offense committed by these two petitions with the help of the other petitions and I find that custodial interrogation will be required for the further investigation of this case and also for the recovery of the articles as well as for some other cases. In view of this presentation for anticipatory extension. Your petition.
Made please. This is for quashing for 156 pre-order. Yes, yes, they have entered appearance. Here, otherwise ready for hearing. This matter is otherwise ready for hearing. No, no, no. No record is required. I will raise some legal issue. No need to go through this trial court record. But look, even the last occasion, they did not appear. Can you see the last order?
So I cannot say whether they were appeared, they
No, no,
appeared or not,
It
because
is reflected
it
in
is,
the
o-
order.
no, it is only the orders at the only prayer of the learned counsel for the parties, list the matter after 2 weeks. That apart, there is no other.
Can you see 26/7/2024 order?
26/7.
7. No representation on behalf of the respondent number 2, though names of 2 counsels have been reflected in the cause list. I'm not insisting for a hearing even today, since they are not appeared.
So,
Your
if
ladyship,
you
can you
submitted
post
with
this
the-
matter next week on a hearing day? Tuesday or Thursday, any day, Thursday perhaps, preferably. It is convenient to this lot.
In which column? In admission column it's
Admission call for admission hearing, otherwise ready for hearing.
we can at best list on 24 or 26. Will it be preferable for you?
24th. Let it be on 24th then. The interim order may continue.
Otherwise, it's a case for quashing.
Case for quashing. Case for quashing.
Still on it. B. Sharma, the learned additional BP, appearing on behalf of the it reveals that there is no representation on behalf of the respondent number 2. And in spite of the reflection in the order dated 26/07/2024, the respondent number 2 remain absent. Let the matter be accordingly listed for admission hearing call on 24th of this month.
For admission hearing.
For admission hearing.
Much.
24th. Yes, it can be admitted, Mr. Sharma.
There's an NI case.
It's a NI.
NI case.
Oh, so you are there and for the respond number 2, anyone is there? State is respond number 1 or what?
Yeah, the respond number, but in the NI, we are formal party.
We can understand.
Fine.
That is okay, but
Respond number 1, my lord. We are respond number 1.
And
2, 3, 4, 5.
5 respondents are there.
My lord.
He will say, good service one any. Service report is still awaited. Okay. 2, 3, 4. Service report is still available. Or আপনার হেতু আছে নি? PCR
Not this year also. It is the office number regarding salary.
and the other this leave petition, those are already disposed of. South the LP was the leave petition also. We disposed. One has represented the appellant. So third distribution in an status one. Further from the office note, it is seen that the service is still awaited for the response number 2, 3, 4, and 5. Let the service be awaited till next date of listing. List the matter accordingly after 2 weeks as an edit.
For orders, I have propose notice.
Your Lordship, in this matter, our petition, we have challenged proclamation and attachment against us. And proceeding is going on in the trial court accordingly. And in trial court, next date is given on 6th of March of this 2026.
Oh,
6th
just
of
tell us
March.
why the matter is in admission column.
For
sorry,
order.
orders column.
Order.
Why?
According to last order, last order of this court, it is ordered that it is directed that petitioner is to appear before trial court within the 15 days from the date of this order, and accordingly petitioner is appear before the trial court, and next date is fixed on 6th of March 2026 for cross examination of PW1. So matter may be closed. Yeah.
So your appearance, your thing that has been accepted by the court, learned trial court.
Yes, Your Lordship. Matter may be closed.
Can be disposed of, yes, from court or anything.
It is not a party, my lord.
Not a party here.
Yes, sir.
Why the proclamation was there?
But my lord,
The order of proclamation, against the order of proclamation only they have come.
but my lord, here my name of PPSM has not shown, and my lord, private, but both are private party. But
Why private party
some
here only?
people, the respondent.
State parties. Why state is not there?
no, my lord, state is not a party.
But why? Why state is not a party? Because it is the
Yes,
order against
so
the
that may, yes,
issuance of proclamation.
yes,
Then that obviously state has to be party.
yes.
Why you have not made state as a party here?
And against proclamation.
In page number 15, you can see this is the case only against the order of issuance of proclamation.
Yes, my lord.
And this court by order dated this your 10/1/2024.
Yes,
It is observed and it was directed to appear before the learned trial court because as per there is a violation of 82 and 83.
Yes.
So considering this aspect, the attachment order and the part is stayed,
yes,
and he was directed to appear.
yes.
and the attachment order and the other orders were kept in abeyance for 30 days with a direction to appear before 15 days. Now they have appeared. But surprisingly, why private party is there, I don't know.
Yes.
It is exclusively a case
yes,
of
my
a
lord.
state.
State
Because
passport party.
case is itself is against the order of
Yes,
proclamation
no.
issuance. So now she is saying that they have already appeared. You have already appeared.
Yes.
Have you annexed any order here?
Yes, ma'am. Last time he has did appear before the court. And, we can't deal with. But, little bit.
Cost for whom?
PW1.
One.
Yes.
That means their appearance has been accepted.
Yes, my lord. Otherwise, my lord, let them fight in the trial.
You are MS?
NJ Das.
You are MS NJ Das.
And
Appearing on behalf of whom?
and appearing on behalf of advocate and not.
You have your Vakalatnama.
Vakalatnama, yes, ma'am.
Because your prayer is to dispose of. That's why I'm asking whether you have filed your Vakalatnama here. Any power has been filed by you?
Ma'am, in this case, in this matter, I am appearing on behalf of our engaged counsel and not.
I can understand you are appearing on behalf of NNAT.
Yes.
But this is your prayer from your side is to dispose of the entire matter. So in that case, that's why I'm asking. Because on your submission, entire matter would be disposed of. What to do? And
If they want to fight for the trial court because of proclamation.
no, it's okay. I'm not on,
Yes.
not on that. Because they dispose of the matter.
Otherwise, her name is not there in the.
Okay, then let's see. You are NJ Das, na?
Yes,
Your
yes.
Vakalatnama is not here, huh? Her name is NJ Das. Done it counsel appearing on behalf of Mr. N. Nat. Done it engaged counsel for the petition. One has presented respondents. The order dated 10/1/2024 by this court, it is seen that the order of issuance of information was kept in abeyance for 30 days, which was under challenge, with a further direction to the petitioner to appear before the learned trial court below within 15 days from the date of. It is submitted by MS Das that after obtaining the order dated 10/1/2024, the petitioner immediately appeared before the trial court below. And here you were granted bail there in the lower court.
Yes.
Appeared before the learned trial court below. Their bail prayer was granted, and case is proceeding at this stage, and proceeding at this case closed up. And the case is at the stage of evidence at present. Around 6/3/2026, the case is fixed for cross evidence of PW. Accordingly, she submitted that the entire matter become practice. Accordingly, paid considering the submission made and considering the submission made by learned counsel for the petition, and also and in view of order dated 10/1/2024, and wherein wherein it is submitted that in view of order dated 10/01/2024, petitioner already appeared in the learned trial court with his appearance is accepted and case is proceeded at. Considering this aspect of the case, the prayer for disposal made by the learned counsel, which is hereby accepted. And the matter is accordingly disposed as rendered.
Obliged, Your Lordship.
45.
Please, Your Lordship. There's an IA Lordship. At this stage, Lordship, it's for suspension of sentence, Lordship. This stage, Lordship, notice upon respondent number 2.
Is a what kind of case?
Lordship, POCSO case, POCSO matter, Lordship.
They have not even taken steps, my lord.
Lordship, we will have to take steps in the main appeal also. We are taking conviction under section 10.
Under section 10.
10 of POCSO. Earlier appeal has been admitted, but now.
Mr. Das,
Okay, that's
Mr. P.K. Das, and oh, sorry, applicant. I would click on with the document. Our bill is ready. Also heard Mr. P. Water, learned additional PP, appearing on behalf of state on number 1. The appeal is already admitted. Scan copy, no, sorry, PCR has already been received. However, from the office note, it is seen that they have not taken steps for issuing this public sum to the respondent number 2. Respondent number 2. In view of this, the appellant is hereby directed to take immediate steps on respondent number 2. But that process is to be there, na? Follow?
Yes, same.
To piece of the root, the piece of the registry rooted parcel law. You will receive
Yes, my lord, office of the
registry. Routed to the office of the public prosecutor. Registry matter 2 weeks as an date to be fit by the registry. In I also same order. This is the application when so the petitioner applicant appellant is hereby directed to take steps for the respondent number. Same order will be after 2 weeks. Your petition is in custody since when?
Lordship, it's Lordship judgment and order dated 19/5/2020. Since then.
19/5.
Well, this is based because criminal appeal, so they may be directed to take usual course in usual course also. Otherwise, my lord, from the our office, we will take the step.
In that case, it will be a bit advanced.
47.
Like.
May it please your lordship, in this case, I'm convicted under section 10 of the POSCO Act as well as under section 448 of the IPC. The punishment sentence is for 5 years under section 10 and for 1 year under 448, and both the sentences.
Yeah, no, it's okay. Whether you have
I have taken steps, your lordship.
Yeah.
Service report.
Your lordship, service report is awaited, your lordship. Office note dated
awaited.
11 years, your lordship.
Record we have already received. Service is still awaited.
Yes.
Your office has already received it
Yes,
on 8/1/2020.
Yes, that regarding that report not yet.
Report is
If your lordship directs, we can take fresh steps, your lordship.
no. They
Not now.
will take Sir Kotaku will take instructions from the
Yes.
because it may serve also. In that case, we immediately can appoint an amendment. Mr. T. Deuri, return the applicant appellant. Sir, report the additional PPA from the office note dated 11/8/2026 and 11/2/2026. It is seen that the record is TCR has already been received. However, the service is still awaited for the respondent number 26. In that context, the learned additional PP, Mr. Bott, is hereby asked to take necessary instructions in regards to the service of notice on this. Let the matter. We want any fixed date or after 2 weeks will do?
After
After 2 weeks.
2 weeks, or fixed day may be given, Your Lordship. Maybe on a Saturday, Your Lordship.
Saturday, oh.
That will be good.
But not listing any case at Saturday. In fact, there are some matters have been identified. So accordingly, it will be listed. So from our side, we are not
Yes,
listing.
yes. Any,
We have categorized some
yes,
cases
yes, I am.
accordingly. 11th of March will do.
Yes, yes.
No, because I'm asking your petitioner is in custody.
Yes,
That's
sir.
why I'm asking.
Yes, yes.
11 March will do or
Yes.
with shorter date? You
No,
want?
no, 11 March.
11.
Only. I'm very grateful.
Please, Your Lordship. Your Lordship, office note dated 12/2 reveals that service is awaited on the respondent.
12/2. This is also same POXO?
No, Lordship, it's under 376 IPC.
37.
Lordship, I had one more prayer. We had to file an IA for suspension of sentence yesterday. Maybe tagged along with the bill.
You're Mr. Borua? Okay, sorry, Puya.
And R. Sharma on behalf of Mr. Akevia.
And
R. Sharma,
R. Sharma. Appearing on behalf of
Mr. Akevia.
Third Mr. N. R. Sharma, appearing on Mr. A.K. Punyan, the learned counsel for the appellate. And also third Mr. P. Bott, in addition. From the office note, dated 12/2026, this seems that the service is still awaited for the respondent. Let the service be awaited till next listing. We have received the test deck record.
Lordship, it's there.
Test record has already been received. Matter is also admitted. It is also next part. It is also submitted by Mr. Sharma that they have also filed one interlocutory application for seeking bail, and which has not been tagged along with the case record. In view of this, next part, the registry is hereby directed to list the interlocutory application along with the present appeal on next list. List the matter accordingly. After 2 weeks, will do.
Date may be fixed, Lordship.
In that case, we will have to take a date on March.
That's okay, Lordship.
Oh, service report is still awaited.
Right.
Let the service report be
Yes.
immediately. Matter may be listed immediately on receipt of the service.
Right, Lordship.
Yes, this is again NDPS.
Lordship, NDPS.
Police code, yes, sir.
Record has been received. Sir.
Pardon? We are not taking the special bench, in fact. They have made the list again, they did these things. And there should be clarification in that regard.
Yes.
Notices are issued by our registry and then again and again. We won't make, anyway, it's a criminal appeal.
Yes, sir. Only
Uh,
the appeal was already admitted.
Pardon?
Appeal was already admitted.
Huh.
It is only for suspension of the sentence, Lordship. The record has been received. So probably on the last day, it was for objection of the learned PP.
Can you tell us, Mr. Bott, objection whether it has been filed or not?
So this now I will have to
The conviction term was
10 years.
sentence was
10.
10 years.
Objection was not.
I
Between the
the order was passed on 18/12/2020.
Yes.
yes, Lord.
So if you have any objection, you was directed to file the objection.
I will have to.
Do you have any information regarding
Regarding that, I will have to check from my office if somebody has filed objection. Otherwise, my
We
lord,
have not received.
then
you have not received that? I to take up part Mr. Diula, the Learned Counsel for the applicant appellate. And also part Mr. P. Waterford, the Learned additional PP, appearing on behalf of state respondent. The as per the order dated 18/12/2025, the Learned additional PP was directed to, there was asked to file objection in objection against a prayer for the in the present interlocutory notification, but it is submitted by Mr. Bott that till date the objection could not be filed by the by the by by the learned public prosecutor. In view of this, how many weeks you need in that?
March 10th or 11th.
Want to fix a date here?
फिर बंद है बंद 10th 11th.
Lordship, PPM directed to file that before the date fixed, so that we can hear.
And well, copy
Yes, the
and
matter-
a
Copy I will submit.
copy of the well, appeal may kindly be sub because
Acha.
copy is not available.
I will submit.
let the matter be listed on 10/3/2025 with the direction to the additional public prosecutor to file the objection on or before the next date of listing and to provide the service copy to the others. At the same time, the applicant is also hereby directed to furnish the copy of memo of appeal during the course of the listing. And the appeal is we have received the case record already,
Yes.
na? Case record.
Then.
Part Mr. Swell's case record is case record received. Appeal is already admitted. List the matter accordingly to the entries. Now, two options are there, Mr. Bott.
Yes, yes.
One, otherwise, we can go, we can hear the entire matter also, interlocutory if it is supposed. And other one thing is whether there is any vernacular things are there,
Yes.
because no, if there is any witness, evidence, etc., is recorded in vernacular. If it is not, then we will do. Otherwise, we have to
Sure.
an order for preparation of this paper.
I'm not sure.
Okay, then we'll see to it.
Yes, sir.
May I please, Lordship?
Yes.
This matter, my lord, for quashing of the criminal proceeding, Lordship, and on last, this court bench passed order on 12/12/2025.
12,
After receiving 12/12/2025, last line after receiving of the trial court report, the interim stay may consider. My lord, this can copy already received. The privacy good case in favor of the petitioner.
Lordship may kindly peruse office note dated 12/2/26.
I'm coming to that point.
12/2/26. My lord, registry has not received fresh steps in respect of respondent number.
Lordship, I'm coming to this.
And
we have not taken steps.
Lordship, so far, my lord, charge sheet concern page 31, and my post title, address appears same.
Huh?
Page 31, my lord.
31, yes.
Yes, of charge sheet on my petition.
Huh.
Page 31, my lord. Here, respondent number 2 and 3, the proper address, this permanent address shown, and this address it is written in the post title, and accordingly to the correct address, notice was served. So, General Clause Act 2000, Lordship, section 27.
No, you have not taken steps.
No, it presumed to be served, Lordship, because I have already ascertained.
I don't
No,
know. Now the
no,
question is there on 12/2, the order, I mean office note, it is saying you have not taken the fresh steps.
No,
That
Lordship.
is the order.
Right, my lord.
Huh.
Question is, my lord, I have a court says earlier, my lord, they ascertain the correct address, but he is a service holder. Permanent home address shown here, and notice also shown to the permanent address. I personally went there, and this address found correct, my lord.
Let him file an
And,
additional
and
appeal.
how I can move to him where he's
Now,
running.
this kind of submission, if you could have made before the this court while passing the order on 19/1.
Yes, lord.
But you remain silent and you are directed to take fresh steps on the respond number 2. So in pursuant to that order, you just take steps. What can be done at this stage now?
If I take a step
Ah.
to this, I can only
So you
to
could,
do
have
to
made
this
a
address.
conviction address at that point of time. While passing the order
Right.
on 19/1/2026 itself,
Yes.
you could have made objection that that we are not in a stage to procure the other addresses. So any other alternative could have been arranged in that case.
No,
Yet
even
you remain silent.
He himself submitted, he even in fact went to the residence.
Yes, residents of
Then,
the. If you went to the residence, then it's okay, good, very good, very nice.
Detailed address and submitted additional
after
affidavit.
coming to the order, this order passed by this honorable court.
Huh.
But at the time of passing the order, it was not harm me because this court was not pronounced loudly. Now, after going through the order recently, I come to know that yes, direction was given to take a step. But I have personally went there. He is residing here. This is the permanent address as per charge sheet submitted, page 31.
So you personally went there
Yes,
for service?
No.
For?
To ascertain the correct address.
Very nice. Then you ascertain the correct address.
This is my nearest place. I am also residing in Hatigao.
Very nice.
And
It is
he is
near-
also residing in Hatigao.
Nice.
Very my neighbor, my lord.
Oh, your neighbor. Very good.
So my
So
lord.
that's why if you have the opportunity to go there and to see that they are present there,
Direction may
then it's very
so does the service, my lord? Direction may
in criminal case,
There is no provision of justice service, my lord.
provision of dusty. How can you?
Then my lord, I can
You
also
just
I
once
can
you
also I
take
can
steps.
I can
Pass the
also
order.
take a step to this address.
What address?
So far address shown in the charge sheet.
No, let him first file an additional affidavit ascertaining his detailed address. Maldeep. This is not the
Yes.
address. But,
This is the permanent address. Page 31 clearly saying this is permanent address.
Can be taken. Otherwise, he made party respondent number 2 and 3 without taking step. Earlier order of this
No,
honorable court.
first
they are-
step taken.
Complied with.
So how
No, one
can
step taken. That my lord returned back. One.
Now your as per you the present address, permanent address same.
Yes, Lord. This is the permanent.
You
This is the
take
permanent.
address.
Yes, my lord. So
Steps.
to this address I can step. I can
You
take.
can take steps. Or we can advise, we can help you
No.
to jurisdictional police station also.
Lordship. My
You
lord,
take steps and put this
only
in
I know that
process.
he is the resident of this place.
Very nice.
So far, the charge sheet concerned, my lord.
Heard Mr. Gabriel.
This is the permanent.
Petitioner and all heard Mr. Vibor and so and so. The office note dated 12/2026, it is seen that no fresh steps has been taken by the petitioner for the service of notice for the respondent number 2, in spite of the order dated 19/1/6. In that context, Mr. Brian submitted that the address which is shown in the chart sheet is the present and the permanent address of the respondent number 2. In view of this, let the fresh notice be issued in the permanent public present address of the respondent number 2. Further, the petitioner is also directed to take fresh steps of issuing notice through the jurisdictional station. Is the matter according to date of
Date may be fixed, my lord.
13th of March.
Otherwise, I pray, my lord, to stay because there is a primary good case, charge sheet saying the allegation, my lord, so far respondent number 3 is concerned that I made forgery by forging the signature of respondent number 3, but respondent number 3 statement has not been recorded.